Yes.
May I please your vote?
Yes.
So for item number 20 is concerned, IA for impeding, but we have not informed the newly impeded parties, Lord. Therefore, Lord, we may be allowed to inform the by sending.
We'll just adjourn it.
Lord.
Mr. Thor learned counsel for the petitioner. Press for an is granted. Press for an adjournment, which is allowed. List of the weeks.
May I please, sir?
20, 21. Both.
Both.
20 and 21.
May I please, sir?
Yes.
I beg permission for listing. This method for admission.
Urgent leave petition for admission.
So this was, the petitioner was terminated.
Uh.
And accordingly, it is moved the petition before this honor.
Terminated from where?
From the contractual service.
Contractual service means government contractual service.
Yes.
Or contract. This is we are taking a bench 4.
Contractual service. Bench
4. This is bench 4 for till Friday. You go to the court number 2.
Not a big.
Contempt, what is the urgency?
I thought team on the path section court. Okay, beg to mention item 32, Malad, to the consent of other side. And I am appealing for the respondent, Malad. Here we have to file affidavit, Malad. We will be filing it shortly, Malad.
Item number
32, Malad.
What is this matter about?
Malad, this matter pertains to termination of the contract. Railway tender, Malad, the contract was terminated. They have put to challenge the termination order.
You take a standard, this is arbitration is there.
Malad. File affidavit to.
Why you need an affidavit? Bring the contract, that's all. Anyway, you want an adjournment, what can you do? On the prayer of the learned counsel for the railways, matter stands adjourned and will be released after 3 weeks.
I am sorry, Lord, it's not 21, only 20. Item number 50, only 50. May I please, Lord, I may be allowed to move on petition for motion. That is about that the Committee of India has taken the access airfare. That is connected with the Committee of India. Matter in brief that the Committee of India has taken access airfare from the hospital to Dhaka. I have challenged. May I come up?
When is the host and when these people will leave for this?
No, that the issue is that it was in 2023.
Okay. These people has gone by paying excess fee.
Yes.
So what is the urgency?
The urgency is not there. The matter was filed on 5/2. Until the reporting is
okay, next week.
Monday.
Monday.
May I please, Lord? In item number 37, my Lord, today I have filed an affidavit in opposition. That may be called for. May I please, your Lord? I beg to mention for lifting of motion material, Lord. Right here. Motion material.
What is the matter?
The tender work of the petitioner has been terminated, your Lordship. Though he has submitted a review application, your Lordship, it has not been considered.
Terminated by whom?
Lordship, the petition.
No, terminated by whom?
By respondent authority.
Who is the respondent?
DC, your Lord. District
contract relates to what?
PWD, your Lordship, construction of road, your Lord.
Okay, right.
May I please, Lordship, take to mention item number 26, your Lordship.
26.
For the day, your Lordship.
26. What is this matter?
Matter is the termination of the tender.
Termination of
tender.
Okay.
May I please, your Lord?
After 2 weeks.
May I please, but by document, item number 34 for meeting, where the instruction to withdraw with liberty to approach appropriate for.
By way of this repetition, the petitioner being aggrieved relating to a dispute or payment of excess freight, the present writ petition has been filed. The Railways has raised the specific stand that such dispute is to be determined by the claims tribunal constituted under the Railways Act. In view of the aforesaid, the learned counsel for the petitioner submits that he may be allowed to withdraw this present petition with a liberty to approach the appropriate statutory uh, authority. First of all, prayer cells allowed. Accordingly, this writ petition stands closed on withdrawal with the liberty as per.
May I, Your Lordship, I beg to mention item number 23. Your Lordship, the conducting council is out of station.
Item number
23. Lordship, kindly adjourn the matter today.
what remains? You are for whom?
On behalf of guests.
Huh?
On behalf of guests.
Rejected. Let the petitioner come. It was a tender of 2017, isn't it? Relating allotment of some shops and all. There was no stay. What remains? This has become infectious. Yes, next. Yes.
I beg to mention item number 47, ma'am. 47. The matter may be come up after 2 weeks, ma'am.
Why?
The engaged learned counsel H. Ahmad is absent, ma'am, due to expire of his brother in prison.
Okay.
May it please your lordship. Lordship, I beg to mention on WPC in Friday, lordship. That tender matter, lordship, due to the stay, lordship, we are not able to supply food chain. Oblige you.
May I please lordship, my lord?
Hmm.
Item 42, ma'am. Can you come up on any other day? Friday or Monday? Friday, ma'am. See, my lord.
42. Series here. Mr. and Mahajan learned counsel for the petitioner prays for an adjournment. The prayer is allowed. Please this matter on next Monday. You keep it Monday. Yes, they receive the written. Interim order pass earlier, shall continue till then. Monday is give the date.
Oblige, ma'am.
May I please, Your Lordship, my
Yes.
prayer is for listing, Lordship. Still being 4 matter, Lordship, non-payment of bill, Lordship. Last listed on last year, August, Lordship. Then after matter. So kindly matter may
When?
Friday.
Please, before
Hmm.
lordship, we are praying withdraw of this.
Why? Anyway. Learned counsel for the petitioner submits that he has instruction to withdraw, seek withdrawal of this bail petition. Prayer is allowed. Accordingly, bail applications are dismissed on withdrawal.
Okay.
Okay, please not. There was called for. There is not accepted.
Okay. Mr. Das, learned additional public prosecutor submits that the case diary is not received. Accordingly, he seeks for an adjournment. Prayers is allowed. Please this matter on
On 7th of March.
7th of March. For production of case diary. Yes.
Contempt matter. Court order.
Where is
Bail-
contempt? Where is contempt? What is the order?
Order operative person, my lord.
Yes.
Para 6.
Tell us.
In view of the submission made by the council parties, the restriction is with the direction to the state respondent to pay the petitioner its outstanding dues as and when the funds are received by the
So where is your statement that funds are already available? That no, I have not been paid.
similar situated person. They are giving
Where is your statement that fund has come? Because your direction is as and when funds are available, isn't it?
Yes.
Show us a statement that fund has come, and despite that, I have not been paid. Then it will be a contempt prima facie, then we will issue a notice.
Similar situation case already on the court. It has been same on same
We
day.
will not look into papers like this. File. Where is your statement that funds are available?
Very start.
You obtain, you file an affidavit, make a statement, then only is it a contempt matter.
Yes.
Learned counsel for the petitioner prays for an adjournment. Such prayer is allowed. Prays for the treasurer. List of the. You are in contempt, Mr. Counsel.
File. Yes.
We must have a satisfaction that yes, funds are there.
Yes, my lord.
Yes. Mm.
On the
Mm.
on page 1, the Honorable Court directed
Mm.
that had filed the that certificate. Petitioner has submitted the certified copy of writ petition order on 23 December. May come to page number 25 of the evidence. There petitioner has different docket number of the
How do you know that this is the number? Any explanation?
had informed me to the
No, no. Forget about your information. What? What? All right. The present application is filed alleging willful disobedience of this court's order dated 27/9/2022, passed in WPC number 4699/2021. Whereby, where is the order?
may come to page number 20 of the writ content.
Whereby certain directions were issued for payment of bills for work executed by the petitioner. Full stop. The petitioner has served a copy of the aforesaid order upon the respondent number 5 on 23/12/2022. How, where is the 4 months? If you do not intimate them, it is in December. Court has asked you to complete the entire exercise from 4 months from date of the order.
Yes.
Now, if you don't intimate them till December, or order was passed on
September.
September. and you served it on December. Now we are not even 23rd of April. Withdraw it. File afresh.
But the petitioner have received some of the amount.
Maybe we do not know, but this is a contempt. Admittedly, this court says that there is no receipt, number one, and there were direction at different levels. Union of India, ministry, then executive engineer. You admittedly serve a copy upon executive engineer, that too on 23rd of December. Court says 4 months from this order. That is always subject to bringing to their notice. You brought a notice on 23rd. How can we issue a contempt notice? Dismiss it or you will withdraw and file a levy.
File.
The learned counsel for the petitioner submits that she may be allowed to withdraw this contempt petition and file the same. Prayer is allowed. Accordingly, contempt petition closed with liberty. None appears for the petitioner on call. Please stop the.
Hey,
Yes.
sir, relating to contact payment method. Last question regarding admission method, we are asked to support file an additional affidavit regarding admission. But after that, my lawyer has submitted a representation before the executive engineer. Putting my lord certificate regarding my lord amount.
Heard, Mr.
Okay, okay.
K. Uddin. No, it order. Okay. Heard it. Right. The present writ petition is filed with a grievance that a sum of rupees 2,35,870, which is outstanding balance against the work executed by the petitioner under the respondent authorities, have not been paid till date. Issue notice returnable after 4 weeks. Mr. RM Das accepts notice on behalf of
Respondent number 225.
respondent number 225, Mr. Nayak, respondent number 6. Full stop. Extra copies, 5 days. Then on the next date fixed, the respondent shall apprise this court either by filing affidavit or the respondent counsel shall apprise this court whether the amount claimed is actually due to the petitioner, and if so, the reason for non-payment of such dues.
I'm representing one also.
One.
One. May I please?
Yes.
This is regarding also non-payment of bill.
Mm.
Some amount has been paid, but the remaining amount has not been paid.
Uh-huh.
Some amount has been paid in the year 2021.
Mm.
And the remaining around the 2 crore 40 lakhs 96,000 has not yet been paid.
Now you have to have 2 crore 40 lakh 964 for execution of government. Okay. And you are appearing for
Respondent 1 and 3, Endowment Tax.
your name?
Sushma.
Give your name. For respondent number Spencer, Mr. Nayak.
2.
Okay.
WPC 123 and 124 of 2024 are similar methods. Let it come along with those methods.
No, we'll see first. We'll see first what is. Let us let them respond, and on that day We'll take up it this item number 52,
50 and 50.
50 and 50, 50 and 50.
Apply.
50 and 52. Hmm.
Lord, if the work has been completed and remaining amount has not been paid, my lord.
The amount is 10206,234.
Yes, ma'am.
Who is the respondents?
Okay, I agree for all the respondents.
Mr. K. Gogoi for all that.
My lord, item number 8.
Wait. Don't jump. Yes. Hmm. Yes. Heard Mr. G. Learned Counsel for the petition. So you are who is the petitioner here?
Yes, I am selected.
The wife has not come.
No, no.
Lordship, may I am for the cooperation department.
Understand. Why wife has not come? This is she wants to transfer it.
Yes, Lordship.
She is having a right for
Yes.
right to continue.
Yes, sir.
She says, okay, I am issueless, so therefore my nephew should run. He is like my son.
Yes, sir.
She is not before us.
Yes, yes.
She should have joined. How do you know?
Yes, yes,
She is also not respondent. How do
Yes,
you know that actually she has given?
yes, sir. But
If yes, then what to do?
there's a notice by the Panchayat respondent.
No. Whatever you say,
They are
we'll
selected.
have to believe it to be true.
Yes, sir.
Is not it?
Yes.
Day after tomorrow, the lady may come and say that I was not even aware. I was supposed to run. My nephew has defrauded me. Then
As per the notice, Lordship, I have been selected. There's a selection by the respondent file.
Hmm.
For the fake fair price shop.
You are the nephew.
So,
Yeah.
not for the representative, that post was vacated, then the Panchayat respondent file,
Hmm.
they went to public notice,
Hmm.
but there are 4 candidates.
Okay,
Yes.
now
They are
tell
also
us.
selected, Lordship.
Huh?
So that part I can be given, Lordship. Annex 4 page 16, Lordship. 16 is the expensive copy.
If you are selected, you will be given a
Yes,
new
sir.
license.
Yes, sir.
Now you are saying that you need a transfer of the license.
Transfer in one part, other part I have been selected, Lord.
Huh?
In one part I have been selected by the respondent file, Lord. Page 18, expensive copy, right, given by the secretary, respondent file.
That's why I'm
Yes, yes.
asking.
Both sides.
Your whole crux is that this shop belonged to my uncle. Isn't it? My uncle died.
Yes.
Now, after death of my uncle, there was a notice for allotting that fair price to somebody else.
Yes, yes.
So you participated. You are selected.
Yes.
Now, is she not a necessary party? We do not know whether she has any objection. She is not having objection. We'll pass a judgment today. Tomorrow they will come and seek a review that see I was not even aware. I am running the shop till today.
Lordship, even the cooperation department is not a party. We have been served a copy, Your Lordship. And probably
We met respondent file.
response number
Uh-huh.
5 is a cooperative society here.
We met secretary of the corporation.
Secretary of the cooperative society.
He is a cooperative society.
I am for the department.
But
Probably food and civil
what
supply
is the
will
procedure?
If Lordship can accept to the notice, as per notice, I have been selected by.
Understand.
Yes,
What
yes.
is the procedure in case of a death of a licensee?
Constitutional legally elected.
Uh-huh.
Legally are elected.
So if legally are
Yes,
gate,
yes.
there is a right upon
Yes,
the his deceased wife.
Yes, yes,
She is not here. Only your statement.
yes, sir.
But yes, tell us.
Yes, yes. So I may be allowed to make response as a part.
Then what to do?
So I may be allowed to make a.
She could be a petitioner also
Yes,
that I have no
yes,
objection.
yes,
He is my nephew. In fact, this is a case of transfer. I want my household to be run by my nephew, this business. Or you get it to transfer to you. You allow your nephew to run. Now, should we advise you business dealings also? They, in the meantime, they are suffering. They are not being able to run this shop. There is a license. Husband died. When? On the prayer of the learned counsel for the petitioner, matters then set down and be listed after a week.
Apply.
The grievance petitioner is that 7 numbers of petition.
Heard Mr. A. Deka, learned counsel for the petitioner. The grievance of the petitioner is that the respondent, Assam Police Commissioner, Guwahati Police Commissioner, Guwahati Police Commissionerate hired 7 numbers of vehicles from the petitioner. However, hire search bills amounting to rupees 1,23,024,306.
1 crore.
1 crore 23,24,306. 123,24,306 has not been paid to the petition. Notice. You accept, Mr. Your name?
G. Bokolial.
G. Fukon Bokolial accepts notice for all the respondents. After revision, whether that it is due, and if due, why not wait after?
For annexer, he pays 86 rupees. For some vehicles, they have already paid.
Okay, this is the amount. We'll let them come and say what is the amount.
That is also they have to pay 5 or
No, that we understand, but problem is that we want to ascertain. On the next date, we'll pass that order. Without notice, it is difficult.
oblige.
They will come with the instruction. We may, if instructions come, we may issue a direct direction. If this is the admitted.
Oblige.
May I please, Lord?
Hmm.
Lord, in this case, actually, petitioner is agreed by an order for deduction of rupees 4 lakhs on account of 26A. Without notice, without prior intimation, without showing so-called, my lord, that has been deducted. So that is, my lord, page 96.
This is railways.
Yes.
But they have taken a specific stand in their reply.
Yes.
If that is the stand, we cannot, now that this is a disputed amount, we cannot decide. Either you withdraw this writ petition, we are dismissing.
Lordship, I want to say one thing.
Yes.
one more thing.
Whatever you say, they are specific stand that you have failed to execute the contract, we have terminated the contract, and there is
2015.
there is no
work
due.
is not terminated.
Huh?
Work has not been terminated.
If
Work
that
has
is
been completed successfully, and
that is their stand, kindly come to page 118.
My lord. That is true, my lord. Lordship will kindly see.
As the contractor could not complete the work in time, the date of completion was extended several times. Last extension was got up, but the contractor could not supply, only 55% of the agreed quantity. As per arrangement, ballast was to be supplied, so and so. Poor progress dated, so and so. In this case, claim of non-handing oversight does not arise. So these are disputes. Go to the.
No.
Mr. Sharma, tell us.
no,
Let
that
us
is-
not waste time. Tell us what kind of decision this writ court will take in view of this.
Lordship, 1 minute.
Yes, tell us.
My lord, page, kindly see page 96.
Yes, page 96.
Page 9.
Yes.
Lord's handwritten, my lord.
Hmm.
Deduction made as per clause 26A. 4 lakhs of rupees, 40,000 per month for 10 months.
Okay.
Now, Lordship will kindly see 26A.
Hmm.
26A clause of the agreement. Lordship may kindly. That is, my lord, page.
Now, before that, before we'll come to that,
My-
before that, come to page 19 and clause 12J,
Page 90, my lord.
place 119,
1.
clause 12J.
Yes.
Yes,
my lord.
read it.
4 lakhs, rupees 4 lakhs was deducted as per the contract agreement provision for not deploying engineer at site.
Right. Okay.
Now, Lordship will.
No, just
Yeah, that is true,
we are
That is true.
giving you some something that so that you can address the court's query.
Yes, yes,
Now you say this is illegal, they
Yes,
say it's legal as
yes.
per the terms of the
yes,
condition.
yes, yes.
Now, if after that, do you propose to say that Red Court will have to decide whether this
On-
deduction
only-
was right or not?
Yes, my lord, I want to say that
Mm.
that order is passed without issuing any so-called note. My lordship will kindly see page 100. This is the certificate issued, submitted to J. Kumar, Executive Engineer, on 2 NF Railway. This is enclosing the certificate of Jejumoni Das that is engaged for that was deployed
Hmm.
to look after the
Hmm.
entire contract. And 102 is the certificate, my lord. The Jejumoni Das himself certificate that I was engaged in the
Hmm.
particular contract.
Hmm.
Then, my lord, hereafter, again, my lord, that was the deputy chief engineer told us that no. What has been given to executive engineer to us, filed us. Again, we have submitted, my lord, 103, my lord. Same documents we have submitted on 103.
Hmm.
That is 2011-2014. We have submitted again. Resume
Hmm.
deployed. Engineer was deployed, but even then 4 lakhs of rupees deduct.
So we'll have to
Contract-
decide that these are documents, they have
Well-
deployed engineer,
My-
and therefore
Therefore,
this
my lord, that
deduction is,
amount,
this
my lord, only
deduction
that
is,
amount.
deduction is wrong.
Wrong.
I have serious doubt.
And my lord, I have stated one I want to say.
If we'll have
Lord, we will
to
kindly
go
see,
to this extent in a writ court, determining the disputed questions of fact,
One more thing I want to lordship, say, paragraph number 10,
paragraph 10 of the
10
writ petition.
of writ petition, my lord, that is page 15.
Just a minute.
Page 15, my lord, paragraph 10. I have stated clearly, my lord, on 23/7/2014 and 2011.
Paragraph, page 10 or paragraph 10?
Paragraph 10, my lord, page 15.
Okay.
Lordship got it.
Yes,
May I read that?
yes.
That your petitioner submits that the petitioner has already intimated the respondent's authority by his letter dated 23/7/2014 and 2011/2014 about engagement of Rijumuni Das B. Civil Engineer, son of so-and-so, as site engineer for execution of the contract, work in both the contextual work allotted to the petitioner's TA number 1858 and 1859 under the same landing Kilchor gauge conversion work going on simultaneously. Page number SN Iman, file number Iman contains the said documents with the endorsement from the competence court. That was there, my lord, in the concerned file. I'm not submitting. RF that document was not produced. That is why, my lord, deducted.
When it deduction was made?
2015,
2014.
14. Then also
14.
lordship whether it heavily timbered.
On another document, lordship may kindly peruse, my.
Where is your completion work?
My lord, may kindly see page 108. There is a certificate issued by the executive engineer on NFA.
So, we are dismissing this deeply.
May be allowed to move before the appropriate for compensation.
Cannot be.
Allowed, but that liberty may be granted.
Mr. Sharma, learned counsel, K. Sharma, learned counsel for the petitioner, says that he may be allowed to withdraw this writ petition and approach the appropriate forum
My-
under the contract dated
My lord, page 34. Detective.
under the contract agreement dated page
My lord, page 34. 15/10/2014, my lord, it is on LNG STL
contract agreement silaba contract agreement number
on
page
on
34 pencil to pencil and as per GCC of the railways. Prayer is allowed. Accordingly, this petition is dismissed with liberty.
Obliged.
What is the amount?
Amount is 38 lakh thousand.
Huh?
38 lakh, my lord. 6,108.
Mr. Bokolian. Huh?
Right.
All right. I got it out. And where are the other items?
Others, my lord, item number 15 and
Item
16.
15, 16.
Right.
Okay. 15 and 16.
In 15.
Okay, amount will write.
Right. Keep it.
May I please? This was the purchase to non-payment of the admitted account.
Huh?
Non-payment of the admitted account by the PWD department. It is. And this is the petitioner was allocated to work to renovate the SDO building. And the total cost, total value of that particular work is 99 lakhs. And thereafter, my lord, in 2018, petitioner started to continue to
Deka. And who is for Mr. Gogoi?
I pay for 2, 3 and 6.
Huh?
2, 3 and 6 I will pay.
2, 3 and 6. And anybody?
I got P9 same years, that's why I
Okay, PNF for 1. Okay. What is the amount? Outstanding?
outstanding amount is my lord,
525 244.
524.
525 244.
Deeply obliged.
Rapid. Non-payment of contract is 6 crore. What is the 11 lakh 30?
11 38 737. You are for?
Lordship, PNRT Lordship, respondent number 2 Lordship.
Respond to another respondent?
I am 1, 4 and 5.
1, 4 and 5. 1, 4 and 5. To who? What about 3? Yes. We are asking you on the next day, whosoever is responsible on the last part of the order, that whether that is due, if due, why not been paid? That's all. Either affidavit or instruction. Yes.
Okay, sir.
Who are appearing for the respondent?
Lordship,
Yes, madam. What is the amount?
9,44,707.
9,44,770.
707.
You are for?
Lordship, PNRT Lordship.
Oh, tell us the respondents, PNRD. Forget all.
Respondent number 2, 3, 4 Lordship, 5,
2, 3, 4, 5,
7 Lordship,
7,
6 Lordship. 6 also.
6, 7. Who, what about 3?
I am appealing for
Yes.
you are for 1.
Hmm?
1.
We do not take that much of time to pass the order. You
Lordship, 1.
take time, more time to say whom you are representing. Yes.
Lordship, 1, 2,
Hmm.
4, 5, 6 and 7 Lordship.
Yes. And Gopalal?
I am 40.
Obliged.
Highly.
Yes.
My lord, we implement the order at page 73,
Hmm.
Annex 10, my lord.
Hmm.
Before that, my lord, what happened? Petitioner before your lordship is the, my lord, fair price of dealer, my lord.
Will issue a notice.
To pay for, because allegation is that in the month of August and July and August, my lord, of the year, some malpractices were done. My license was granted only on, my lord, September 2022, 2020. After that period, and
is on the reflected on the report that I have not even started the fair price. Lordship kindly see page 46, my lord, down below.
Where is your license?
License is there, page, my lord, page 21. Top, my lord, dated 14/9/2022. And my lord, in the report conducted by the authority, page 46, down below, my name appeared, Ziabur Rahman.
No. Your license is on
14/9/2022.
2022, but the allegation is not against you.
There are others. my lord.
Others. So they had a
I don't have anything to do with them, my lord.
no. It is general that these people are doing this. Thereafter, there was an inquiry. In inquiry, others were having licenses for earlier
In the
period.
inquiry report, there are findings against the others, my lord. So far as-
You also not.
No, my lord, kindly see page 46, my lord. Page 46. Page 46 down below, Ziabur Rahman. In our field page, they so inspected about this.
Now tell us, that's why we have to issue a notice. Your license was suspended and these customers were tagged with some other on December 2022.
Yes, ma'am.
We are in January 20,
Yes, ma'am.
February
Once we filed the writ
24.
petition, my lord. Once we filed a writ petition, notice was issued as to why this suspension was done, my lord, and tagged. That on the next date, my lord, they come up with an order saying that, my lord, on the date of issuance of notice,
No,
my
understand,
license was
but
cancelled.
if we pass an interim order, that will be upsetting a thing which is been done in the year December 2022. And in the meantime, your license is cancelled. Now it will amount not only staying the judgment and restoring a position which was prior to the December.
Yes.
Is it not?
Yes. That is,
So if it is, then we are issuing a notice. That
Otherwise,
is what we started.
otherwise also there is a statutory appellate provision is there
My
under
lord,
Rule 29.
that authority is already
Rule
abolished by
29.
government. my lord.
Rule 29.
Rule 29 says,
Okay, you raise that on a
Lord,
my lord,
Heard Mr. J.M.A. Choudhury, learned counsel for the petitioner. The petitioner is aggrieved by an order dated
Commissioner to
312
accept.
order dated 22/1/2024, whereby license of the petitioner has been cancelled after an inquiry. The license of the petitioner, license of fair price shop
yes, ma'am.
fair shop of the petitioner has been cancelled. Prior to that, the license of the petitioner was suspended by an order dated 3/12/2022. Issue notice returnable 4 weeks.
Okay, I am for all the
Gogoi
respondents.
accepts
All
all
the
the
respondents.
Gogoi for all the respondents. No, Mr. Gogoi learned counsel has raised an objection as to the maintainability of the present writ petition, having alternative remedy of appeal. Issue notice returnable 4 weeks. Gogoi accepts notice on behalf of all the respondents. The maintainability of the
My
writ
lord,
petition.
with regard to maintainability, my lord,
No, maintainability writ petition is kept open.
Lord, oblige, Lord.
You let him come with the, we will not decide
my
on the
lord, so
motion.
far the divisional commissioner, as per the act, my lord, the commissioner means divisional commissioner. Divisional commissioner post is, my lord, can abolished
Now
by the
it was
government.
plus secretary, Lord.
Any, you see
Commissioner
that,
secretary, it was secretary, Lord. Oblige, Lord.
Non-payment of contractor fee,
Hmm.
completion of the work.
Hmm.
It may say to look to page 85. That's the completion certificate. Everything is there.
Amount
3 crores 29 lakhs.
317,04374. Gogoi accepts notice
All-
behalf of
all
all the
the
respondents.
My lord, only the pendency may not be, some process is there. If your lordship.
So what लिख दीजिए वहाँ और pendency shall not be a bar to release the amount. Yes, Mr. Bora. BTC. BTC. Wait for some time, Mr. Dutt. Same item 48, 49.
For a timing, there is good part.
Yes.
About the tender process for the sale of land.
Hmm.
About the technically non-qualified bidder
Hmm.
who ought to have been declared non-responsive
Hmm.
has been issued the letter of acceptance.
Hmm.
It might not comes to the pages, my lord.
179.
My lord, 179. It's the tender revocation list, wherein I have been declared technically qualified, but the private respondent, my lord, has not been declared technically as.
Where is space?
Page
179.
179 is the revocation list, my lord. I am qualified, as well as the private respondent.
Who is running?
No, my lord, it has not been issued. My lord, the financial with the net worth certificate, income tax return, and balance sheet for 3 years were required to be filed. They have not done so.
Where is the technical evaluation first?
Technical evaluation, my lord, page 179.
That is what I am asking.
My-
Let us see from that
My-
where is your position?
My
Where
lord,
is his position?
170.
Your name is?
My name is Pankaj Jyoti Hazarika, my lord.
Provisionally qualified.
My lord.
What is the name of the other respondent?
Tutumoni Das Gogoi, serial number 8, last.
Okay. Then
Now, my lord may come to the requirements. Requirements, my lord, at page
no, this was done way back on
12 of them.
12th of January.
12.
Now they proceeded.
My lord, letter of acceptance has been issued.
No, they
My-
proceeded. This is technically qualified.
Qualified.
Any question of any price bid?
Yes, my lord, it's a 2-bid tender.
Where is that?
My lord, price bid at page, sorry, the bill of some quantities, my lord, page 180. Private respondent is H1, my lord. I am H2.
Now what can we do?
My lord, the
You have
license,
become wise after technically you are qualified.
my
Why
lord,
have you not challenged?
my lord, that we are challenging. My lord. We have submitted.
So we are issuing a notice at this stage.
My lord, the license has not been issued.
Heard Mr. P.D. Nayak, Learned Counsel for the petitioner. Mr. Your assistant, heard Mr. and
It's a caveat.
Mr. I. Chaudhuri, Learned Senior Counsel, assisted for M. Sharma on the behalf of caveat. Caveat stands research. The present
department.
petition is filed assailing that the tender committee has wrongly declared the respondent number 6 as technically
Qualified.
qualified bidder, ignoring that tender of the respondent number 6 was defective. Full stop. A notice inviting EBIT was issued by District Collector Jorhat District, inviting shop-wise electronic bids for grant of IMFL retail within inverted comma of license in Jorhat District. The petitioner, comma, the respondent number 6 and some other interested tenderer participated in the tender process. On 12/1/2024, the bids of the bidders were evaluated and bids of all the bidders were uploaded on 12/1/2024, wherein both the bid of the petitioner and the respondent number 6 were found technically qualified. There is a better word, technically viable, responsive, better, responsive, technically responsive. Full stop. Thereafter, the tender committee proceeded further to open the price bid, and accordingly, financial bids were opened on 24/1/2024, wherein the respondent number 6 was declared to be H1. On the basis of such determination, they proceeded with the tender process. Now the petitioner is aggrieved with allegation that though the respondent number 6 was a non-responsive bidder, his bid has been cancelled. Issue notice returnable after 4 weeks. In the meantime, parties may exchange their pleadings. Mr. KP Pathak accept notice on behalf of
Respondent numbers 1, 2, and 4.
1, 2, and 4.
He-
Mr. M. Sharma accept notice on behalf of respondent number 6. Extra copies 5 days. Full stop. Though Mr. Nair has pressed for an interim order of stay, however, considering the fact that the technical bid was evaluated and uploaded and published on 12/1/2024, and thereafter the technical financial bid was opened on 24/1/2024.
LOI has also been
And it is submitted that LOI has also been issued, and the petitioner has awaited till consideration of his representation. This court at this stage not inclined to pass any interim order, inasmuch as admittedly the petitioner, the respondent number 6 is the H1 bidder. Such, however, it is made clear that the LOI already issued shall be subject to outcome.
But the government may consider the aspects about the pendency of the
Either you this pendency, or we cannot have an authority who will decide where we are in the
parallelity.
no,
I understand.
that cannot.
Fine.
Yes. Next case.
But LOA as well as the rights.
Okay. Right.
Deep. Along with 7, item number 7.
That 50 is being John will take after some time. 50.
50 is separate. 52 and
No, but BPCL will
BPCL.
take up this with 3 matter together. 50, 52, and 7. Okay, wait for Mr. Doctor. Wait. Yes, what about the BTC? Okay. Yes, where is Mr. Das? You don't want money. You don't want money.
But the tender is reflected that the honest man that right, honest man will be 19 lakh something and other is 26 lakh. Earlier it was something different. Earlier all have exorbitant money, 2 crore, 2 crore, 1 crore.
Here to put at 1 crore.
Highlight if it.
If they give, if
We want to see the record under what circumstances, and you say that there is no requirement of any wide circulation. Why? That no requirement of notice in 2 newspapers.
yeah.
What is that?
My lord. There is
Rule of what?
Rule of that, you can read that. My lord, my submitted that to local financial rule 1938. What is the that has been amended is 2005 rule.
No.
50 over
This relates to what?
tender.
Tender of what? Public Works Department.
No.
This is forest.
Forest.
And what about is it BTC? BTC has adopted that rule. E-tender. This was an e-tender.
My lord, the problem is that BTC area doesn't have e-tender. And all the forest other has all e-tendering system. They doesn't have. They are in the
Now this
old
is also
system.
not e-tender.
No e-tender. That's why
This is
all
not
the it should be e-tender.
We need to examine.
What
Yes,
is this?
what is
No
your
e-tender.
instruction?
no. Today I don't have the instruction because it's in the motion stage, my lord.
No, motion stage we understand, but there is a direction saying that you will obtain
I have not
instruction.
received my instruction, my lord.
There is an interim order saying that
Yeah,
Mr. Asbora learned counsel appearing for BTC submitted he needs instruction.
No, sir.
You have submitted the earlier tender notice had been cancelled due to the exorbitant rates bid. You file an affidavit.
Not
You
That point is concerned, my lord.
You continue with the work, deposit,
my lord, because-
deposit 2 crores.
Huh.
We'll return it to you.
You lost of list.
Okay. Fine, we're
no.
vacating this stay order.
No,
pay
my
people.
lord, there is a reason, my lord. You lost of list.
We want to know the reason from them by an affidavit.
We file, we put it 2 crore 7 lakh for 7 years, my lord. That is the wrongly they quoted.
Hmm.
And my friends, they quoted 1 crore 81 lakh.
For
7 years that was, not 1 year, my lord. 1 year is, bid bill was 28 lakh. We submitted 29 lakh 5,000. 29 lakhs our
So
annually.
we want that to
And
be
two-
heard
two
from
crore
the
is the-
BTC. Where is that earlier tender notice?
You know, I'll let them down, please. Another one, my lord. Yes, 26, my lord.
What is the period?
My lord will kindly see one thing. My learned friend has said it is for 7 years. See at page 33. 33. If your lordship kindly see on the right hand side column, minor minerals annually. So the rate which is quoted was 2 crore 7 annually. Kindly see minor mineral annually. 2 crore 7 lakhs. This has been cancelled by the authority. Now, only one difficulty is here. They have now in a local newspaper in
No,
Boro.
that we have seen.
So how they is a vernacular, at least you can use it. And that is all 3 partisans from Tirang district. Kindly see the rate, how they have quoted. And all I have seen, my lord, all forest minor mineral under mineral concession rule, it is all e-tender. Only BTC area doesn't have
What is the Assam minor minerals rules prescribed?
consent rule. It should be now it is all e-tender.
No. What is the otherwise rule prescribed? Minor, forget about this. This is relating to PWD and FAR.
And that rule by Senior Council applied financial rule. Paragraph 15. Paragraph 15, that rule. But that has even that 2005 rule has come. Now, minor
lord,
one local purpose, my lord.
My lord, we are asking under what provision it is done.
One
It is
local
done under 34. Assam Minor Mineral Concession Rule 2013. What it says, 34 public notice for inviting expression of interest, bid, open auction. A public notice 21 days shall be published for inviting bids of conduct. Next, in addition to publication of notice writing bracket e-auction under sub rule 1. The system is e-auction. Today that old method, conventional method is gone. E-auction. Let my learned friend BTC Bora respond to this. Why not e-auction? Let him respond. Why not e-auction?
What is this material? This is sand. Sand to be extracted from forest.
Yes.
And this is minor mineral to tender under this concession rules 2013. That has been issued.
My lord, we have
some forest material.
My lord, only listing that rule we have done substituted by word comparative bid. And there is substituted, my lord. That now BTC authority has adopted the policy, my lord.
We want to hear BTC. You are not representing, you are the beneficiary of BTC's
that
action.
Is why, my lord. That is why
we want to hear BTC. There was a instruction were to be given. BTC court was prima facie satisfied that it is an loss to the public exchequer. We are also earlier court. We are also of the same view. Therefore, we want BTC to file an affidavit. We will decide it at the motion stage itself.
My lord, BTC also clarified the matter. Whether the 2 crore earlier we offered 2
that
crore
they will let them file and then we may ask question.
Let the notice.
Mr. S. Bora, learned counsel for appearing for the BTC submits that he needs further time to obtain instruction in terms of this court's order dated 19 to 2024. Prayer is allowed. List this matter on. Give a date. But Mr. Bora, you file an affidavit and keep the record. Full stop. We are giving 5th of March 2024. On the next date fixed, BTC Mr. S. Bora, learned standing counsel for BTC shall also be ready with the record pertaining to the tender in question. Tender, full stop. The Mr. Bora may also clarify, obtain instruction and clarify whether the prescription made under rule under Assam Minor Mineral Concession Rules 2013 so far relating to the auction / tender of minor minerals has been followed. Full stop. Let us see what is.
This is not only uploading of the first
No, no,
stage.
no.
Second stage also, 1 second. Second stage also, it is to auction only. This is price is given.
Same way, my lord, my senior client already get tender. On same way.
So you file.
No, not e-auction.
Challenge it.
Those are not the grounds before, cannot be a grounds to allow
But
some.
earlier tender is go, my lord, because authority has not granted me mining mineral not granted me within 45 days. That is why we could not submit. Our tender has been cancelled. Earlier one, my lord. 45 days we want to file.
We
all
understand.
clearance.
We cannot decide
That is
all
why-
these things. We want to know whether the procedure prescribed is followed. And we are little bit apprehensive on the ground that a person who quoted himself 2 crore is now been settled with a 28 lakh or something
19
like
lakh.
that.
19 lakh.
19
My
lakh.
lord, my senior,
Even the reserve price is 28 lakh.
they also quoted 1 crore 81 lakh, my lord, earlier. 1 crore 81 lakh. Actually, it is not. It is, God bill was 28 lakh. We offer 29 lakh something.
We want all this in on affidavit. You file an
Yes, my
affidavit.
lord.
Okay. In the meantime, the private respondents also.
I will file
File
it
their
after
pleading.
after his clarification, my lord.
Mr. Bora, it's your responsibility.
The interim
Interim
order,
order pass earlier shall continue till.
Hello.
there are two cases,
Two same.
two different mining.
We'll say that only. That
Yes.
was, we have not said anything about the tender. We say he has short time. We have adjourned and he will
But I
clarify.
think I have not come across that why BTC is not going for e-tendering process. So e-tendering is not 34. Yeah.
The record will have, they will have say something that what is actually, what whether he's correct or he is correct and what is, the record will speak for
Yes.
itself. We'll see that record.
My lord, but the provision of the act is there. You cannot go beyond rules and act.
Yes, that's
So they have to explain
that's
that they are not relying on the rules of Assam Minor Mineral Concession. That's it.
Yes, my lord. Now we will get a chance to challenge his tender, my lord, because same tender, my lord.
Oh,
I
Mr.
will-
Amir, what are you arguing? Can that be a ground in the court of law that some illegality has been committed, so you allowed to commit another illegality?
Hello, my lord.
Yes.
Contemner he has been transferred, a new person is holding the post. So the I for implement is the present chief engineer of public engineering.
Have you served a copy of this order to the contemptor? No.
Uh,
You have said there is a contempt pending. What contempt pending? What is to his to do? Learned counsel for the petitioner submits that she may be granted some time to intimate the new incumbent as regards non-implementation of this court's order dated
35/2023.
order dated
35/2023.
3005/2022 passed in WPC number 760/2020. Accordingly, matter stands adjourned listed after 3 weeks. You serve a copy, then file an additional affidavit that after that it is. Motion. One first call the seven.
My lord,
Where is the brochure or something?
Yep.
How do you know that? What was the you have prescribed? 4-1?
Yes, no, page 5, my lord. Page 5.
Page 5.
Page 5.
last one, my lord, page 5. Roman, take.
No, where is that? Where is that? What does it say? Which page, Mr. Roy?
Five.
Huh?
Page 5, last paragraph.
Page 5.
Last, yes.
Page 5.
The
Okay,
line should be available with the applicant.
just a
The land-
minute. To Roman 6, land applicable to all categories. Okay. Land applicable to the applicant as on the date of the of 19. So, yeah, basically there are multiple owners.
Yes. This clause was newly inducted. Earlier that this was not. Only no objections.
Because your idea is that suppose there is a dispute,
Yes,
why
yes.
should we suffer?
Yes, yes.
Now tell us, in your case, you say that there are all these are co-pattadas. What do you mean by co-pattadas?
My lord, in a patta, my lord, there are, my lord,
What is a patta?
patta is an area of land, my lord.
Patta is area of land.
Yes, there is a number of, my lord, landowners are there. Patta is the same patta. And my lord, no objection certificate page 33. my lord.
No, they are saying you'll have to execute the lease deed.
Alright, this is impossible.
To take search that you ought to have searched the different.
Because, my lord,
If it is impossible, they have rightly rejected.
my lord, because, my lord, one, my lord,
Because your whole case is that these are my co-pattadas. So therefore they have given some.
co-pattadar, it is right, my lord, but it is written, my lord, co-owner. But lordship kindly have a look page
But
33.
what is the difference between co-pattadas and co-owners?
Suppose there are, my lord, 5 persons in a, my lord, in a patta, my lord. They have respective land, my lord, and house also. But they are not interested with, my lord, this outlet, my lord. Page
Okay.
33 is very clear, my lord.
Okay. In your case, the limited issue is admittedly they are in
No, Lord, I am clarified. Lordship kindly have a look. This is submitted, my lord, page 33, my lord.
case 33 of
Yes.
one.
My petition, my lord. Co-pattadar, my lord, clarified that, my lord,
That is a difficulty in your case. You have yourself says they are my co-owners.
Owners.
no,
Because patta is a title.
no, this is, my lord, text.
Suppose you go to that this man, what is his name? Who entered a lease agreement with you?
Yes, Dilip, my lord.
Dilip. If Dilip wants to take a loan from a bank, okay?
No, my lord.
No, just for a minute. Dilip wants to take a loan from the bank with this plot of land. He will not be treated as an absolute owner of this plot of land.
No, lordship
There
kindly-
are co-owners.
I have understood, my lord, but here, my lord, co-pattadar is clarified that this part land belongs to, my lord, this petitioner, my lord, Kamal Coach.
If they are not happy, how can we be happy on that? Yes, next, we'll wait, we'll hear other case and next case.
In the next case, lordship. In this case, lordship, they have given opportunity to submit their rectified documents, but he has not submitted. Admitted.
Because he said that I was ill, I was this, that we cannot. Who is this petitioner? He says that she admitted that
Admitted,
I
not
could not
submitted.
submit during the prescribed period
Hmm.
because I was having some difficulty.
And we
If you have not considered, how can we replace your visa? Who is the petitioner here? None appears for the petitioner on list after a week.
No.
Yes, doctor.
Here,
Now, what do you address on that?
Now,
In your case, what is the fact?
in my case,
Same.
my lord, the clause 4 your lordship has seen.
Hmm.
Clause 4 has one aspect that if the suitability of land is in question for
Hmm.
some reason, then I will be given a period of 90 days to rectify the thing.
Where is that?
Your lordship will kindly come to page 29.
Page 29.
Page 29, after the heading group 1, 2, 3.
Page 29.
Yes, after the headings group 1, 2, 3.
So you are basically on eligibility criteria of individual applicants 4. Then 6 is land applicable to all categories.
Yes.
Now which clause now?
Now, under group 3,
Group 3.
second paragraph.
Applicants who have not offered the land in the application.
Third paragraph. In case land offered My case falls under group one. Applicant
one.
having suitable piece of land in the advertised location and area, either by way of ownership, long-term lease, for a period of minimum 19 years, 11 months, or as advertised by the OMC.
This is the first condition.
It is the first condition.
Hmm.
Now, kindly come
You
below.
come under group A.
Group one.
Group
Group
one. I
one,
come
group
under
one.
group one.
Hmm.
Now, kindly, there is a sort of proviso.
Hmm.
Your Lordship will kindly notice it in the second paragraph below group 3.
In case.
In case, yes, in case land offered by all the applicants under group 1 and group 2 is found not suitable, not meeting requirement,
Hmm.
then these applicants under group 1 and group 2 along with applicants under group 3 who did not offer land along with application would be advised by the OMCs to provide suitable land in the advertised location.
Hmm.
Straight within a period of 90 days
Hmm.
from the date of issuance of the intimation letter to them through SMS email.
Hmm.
Now, this particular provision has been totally missed out.
Lordship, it will come
Just,
after.
This particular provision has been totally missed out. And alongside this provision, your Lordship will kindly come to page 31.
Yes.
Page 31, clause M, serial number 2, under group 1.
Clause M.
Clause M, serial number 2.
Hmm.
Self with members of family or owned exclusively by family members, if that is the situation of ownership.
Hmm.
Now, additional documents which are required, consent letter in the form of affidavit from members of family as per Appendix 3.
Okay.
Appendix 3 is there in the in the part of the
Okay.
brochure itself.
Okay. Understand.
Now, I have supplied this in the Appendix 3. Now,
Where is your
the affidavit.
no, not affidavit. Where is your lease deed land?
This deed is at
Your
Lease
land
deed.
is a lease or self-owned with family.
lease.
So if it is a lease, then it will not come under self with members of family owned exclusive by the family member.
Yeah.
Self means the person who has applied, his land is not lease. It belongs to him, but it is along with his family member. That's why no objection has come. Self. Self means applicant.
So the similar condition is also there in clause 3. Next
Clause?
page. Next page, 32. Self with other owner.
Land
Family-
owned by third party in part or full.
Yes.
So it is your case
That-
land party
There also I am required to submit it. An
consent
affidavit
letter in the affidavit power of attorney from the other owner.
and in Appendix 3.
Hmm.
Now, only objection taken is that, my lord, the
Hmm.
lease deed, which is that as page 118.
Hmm.
Now, in the lease deed,
Just a minute. No, this will not come. This is group 2. This is not applicable to you.
no, this condition of submitting the consent letter in affidavit, in case the land is not owned by me, that
No, if within a period, in case of applicant fails to provide suitable land within the prescribed period or land provided found is not meeting the laid down criteria, the application would be rejected. Now, within a period of 90 days from date of issuance of intimation letter to them through SMS email,
Yes.
the land offered by the applicants under group 1 2 is found not suitable, not meeting requirements, then these applicants under group 1 and 2 along with applicant group 3 would be advised by OMC to provide suitable land in the advertised location.
Yes.
Okay, so option is that they will give you an option in the suitable location stress within a period of 90 days.
90 days.
This is this argument we can look into, but the argument that various situation of ownership for defining own farm offer are under. So here clause 2 self. First is self, that is full. Second is self with ownership, and whether then or a self. If you
3. Next clause 3.
next not clause 3, clause is self with other owner, family
Yes.
members. Self must be there. Are you there? It's a lease. So that is gone. Now come to
Now-
group
Now, even
Now
if-
come to group B. Let us conclude this.
Yes.
Now come to group B. Land owned by third party in part or full.
Cool. Then
And
also,
that leads to farm offer, not to your offer. Come to group 2. You are not in the group 2.
Is the group 1.
That is a farm
Okay.
offer.
in,
So
in,
that part is gone.
in case, my lord, it is also not done.
No, not in case. It is.
Yes.
Yes.
Then, then also, my lord, they are under an obligation to give me a time period of 90 days
No.
to rectify the thing. Because what has been done, my lord, that in my representation also I highlighted this, that the particular clause 4.1 read with the clause M creates a sort of confusion. And that is why in the representation I have highlighted that although there is a requirement of the lease deed to be signed by all of the partners, but in the affidavit it has been clarified. All the partners have clarified that they have got no objection if the land is settled with the applicant. Land is leased out to the applicant.
Yes, Roy, what do you say about this?
Lordship, this rejection was Lordship not committing the clause, not meeting clause 4.1a
So that is a requirement.
requirement.
So if that is not, his argument is that
Lordship, 90
suppose
days when given Lordship, if his land, after giving the land, selected land, if the land is not meeting our criteria that.
so the second inspection.
Second issue is
Where is the
alternative
when second inspection after land is given after tender? There is a provision
provision.
which says that after this the officers will visit site inspection. Then if they are not satisfied,
then 90 days you will come.
where is that clause?
Lordship, that still verification.
Because there, yes, now I can. There are two stages. One, you have given your documents and everything.
After
On the basis of documents, they are happy. They have given you. Thereafter, there will be field verification. Then they will look into this matter. If they are not, according to them, is not as per requirement, then they will give you a time that you please change it around it if possible.
Now in that circumstance, assuming that argument from their side, what transpires in the record, my lord, it is only a rectifiable defect.
No.
Because why I am saying that the lease deed, when the lease deed was executed with no objection from all the lease owner. I mean, all the partners.
A notice, not more than that.
My lord, may I just conclude my
Yes.
the lease deed was executed with no objection from all the co-owners. And the particular, what is the objective behind this particular clause? The objective behind this clause is that the BPCL should be in a position that the retail outlet remains functional for a period of 19 years at the least without any disturbance from any quarter. No question is raised on the question of ownership or lease. That criteria has to be satisfied, for which this clause has been inserted, that you come with a lease deed and you come with a no objection. Now, there may be a misunderstanding on the part of the applicant, but the applicant represented on this line that because of the clause appendix 3P, if your lordship will kindly see page 11. So what I have submitted before your lordship now, my lord, that is only on the basis of the understanding of the clauses in the protocol. Your lordship will kindly see in the page.
There is a difficulty here. Your understanding of the clauses of the voucher
No,
and our understanding of the clauses of the understanding, the Honorable Apex Court says you keep behind.
No, that has to be.
Keep behind and let us, the employer, interpret their document.
No, Lord, what I am submitting is.
Yes, I am at page 112.
Yes, that is the understanding of the petitioner, my lord. That's why the confusion has arisen. Kindly see serial 1, that the lease deed was signed by the lessor on the basis of NOC offered by the co-owner. That as per appendix 3, all the co-owners along with the lessor has declared to lease the state plot of land whenever required, if I, that is lessee, am selected successfully. Attachment enclosed. The contents of the guidelines in clause 4, subclause 6A and the contents of appendix 3 seems to be confusing for us. That is the reason, my lord, this confusion has arisen. And it's a bona fide confusion. My lord, if they have a dispute, and the total, what I have done, the total plot of land is measuring 3 bighas. We are
three co-personers in that particular land. It's an Ismaili property, my lord. And I have only leased out my lessor has leased out only 3 kathas of it. So it no way it encumbers any of the part of the rights of the other other partners. And the other partners have given affidavit on the point that they have got no objection. Only mistake that has been committed on my part is that instead of putting the affidavit, my lord, as per the requirement of an XRP, those persons ought to have been joined in the list. Well, that's a rectifiable defect. Ultimately, it is the interest of the PPCL which has to be secured. And
Yes.
yes.
That is to be secured, and they are the base just to secure it.
Now
It's a commercial transaction.
Now, it's a commercial transaction, I can understand, but then they are taking a very critical view of the matter. The substantial justice has to be looked into, my lord. This is a mistake which by no means of imagination.
Admittedly, you don't have land.
I don't have land.
You don't have land.
But
Admittedly, you are offering the land on the basis of a lease deed.
Yes.
Is not it?
Yes.
Admittedly, the clause prescribes that in the event of the lease and there are multiple owners, all the owners will have to execute the deed. Now, this has been admittedly violated. So, we can issue at best the notice, nothing more.
Now, my lord, whether today, tomorrow is the date for second lot of lottery. It has been allotted by a lot of lotteries, my lord. I came out to be the first person, and that's why it came to me. Tomorrow is the date fixed for the second lot. Now, if the second lot is allowed to be held, and subsequently, my lord, on final hearing, your lordship comes the opinion that this is a rectifiable mistake, my lord. Unnecessarily, my lord, it will involve multiplication of proceeds. That is what I am on. My lord, in similar circumstances.
Okay, we'll decide then this petition right now. Because it will become infractious if you don't pass an interim order. Isn't it?
I don't say that it will become infractious, but it will give rise to multiplication of proceeds. My lord, your lordship knows, my lord, section 44 of Transfer of Property Act is very clear. I can lease out a property even if I am a joint partner. I can lease out.
Challenge the tender condition. What is this?
No, I am not saying that the tender condition is
That
bad.
this is in violation of our Transfer of Property Act. They have decided the formulas that this is the lease deed 19 years because we are investing money in this project and therefore we need a clear title or clear lease deed. Therefore, they put a condition that if you are taking a lease, if one owner, no problem. If the owners will have to, we do not find any infirmity on that. You have participated in the tender. Others are having that. You are not having. What can we do?
Others are still not having. Whether or not the others are having that.
That will be a different.
That they will look into tomorrow. As on date, I am having everything. Others are not having. That's why it was given to me. Tomorrow they will decide whether or not the others will come into the picture. Tomorrow is unborn, my lord, as of now. What I am on is, my lord, I am before a court of equity. Admittedly, my lord,
court of equity. It's a court of equity. There are standards of application of equitable principle in different contexts, different situations.
But your lordship will kindly consider one aspect of the matter. The lease deed is there. According to them, the lease deed is invalid. All that they require is that instead of the affidavits which have been filed, the parties ought to have been joined there. My lord, it is ultimately a curable defect. The opinion of the consent of the parties, all the partners are there on record. Page 145, your lordship will kindly see. The lordship will kindly see page 145. When the permission was granted, at the time of grant of permission also, my lord. Page 145, your lordship will kindly see.
Yes.
So page number 2.
145. Sorry. Yes, your lordship will kindly sit at page 145, clause 2. That Sri Prakash Pukon is applying for retail outlet dealership of Bharat Petroleum Corporation on Bogijan
under open CC1 category against the advertisement appeared in Assam Tribune dated 20. In case clause 3, that in case Sri Prakash Pukon is selected for RO dealership, I will either lease the above mentioned piece of land to oil company or to Sri Prakash Pukon for setting of retail outlet facilities at the above mentioned location as per the site plan duly signed by me. In case of lease, I further confirm that I have no objection if the subject piece of land leased to Sri Prakash Pukon is further subleased to the oil company by him as per terms of the oil company. Every affidavit, my lord, all the partners have shown this affidavit. Every affidavit contains this clause, and it satisfies the requirement. Yes, there is a mistake in the sense that instead of signing the affidavit, my lord, it will ought to have been joined with the lease deed. That has not been done, but that's a curable defect, my lord. And I acted under a bona fide impression that since there was a clause annexure 3B requirement, and therefore, my lord, I did this. And their time limit is 90 days. If a chance is given to me, I can subject to permission granted by the authority.
Yes, Mr. Royce, tell us about that provision.
Lordship, kindly come to page 143, the permission given, lease permission given, Lordship.
140.
In my next 143, the permission, the NOC given by the Deputy Commissioner, District Commissioner for the purpose of lease. What is the purpose of that?
143 is a affidavit. Surajit.
No, the permission is there.
Where is? That is page 132.
132. NOC.
The purpose of use, Lordship, kindly see for residential use on. The permission is lease is given.
No, that is not the ground on which you have rejected the lease. You have rejected the lease on a different ground.
Because
purpose for use, that is the class of land and the category of
class
land.
of land is bari, Lordship, not commercial land.
No, tell us that this 90 days is applicable.
Thereafter, if the land doesn't meet the criteria, Lordship, thereafter, Lordship.
Where is that?
Lordship, kindly come to in the brochure, Lordship.
There is a provision.
Yes, Lord.
After this selection is not absolute. There is a committee of site visit. Where is that?
Lordship, the final page 27, Lordship. Final processing of the application of the provisionally selected candidate.
Where?
Page 27 of the brochure, Lordship. After application, Lordship, the draw of lot. Page 26, draw of lot. Thereafter, Lordship, processing the candidate provisionally say draw of lot, bidding process, its location. So
In case the ISD is not paid and or requisite documents are not uploaded, applicant would be given another 10 days time to upload the requisite documents.
then come the land evaluation. Thereafter,
Where?
next page, Lordship.
Page
28.
Yes, page 28. Is eligibility criteria.
Thereafter, land evaluation.
Huh?
Thereafter, land evaluation.
Land application.
Evaluation. Thereafter, Lordship, field verification of the credit.
No, there is nothing like that. Page 28, this is the repetition, Prakash Phukan. Isn't it?
Page 52.
Huh?
He is referring to page 52.
52?
Yes.
Okay, land evaluation. I was at page 30. Huh.
And what your lordship was indicating at the beginning, Lord, that is at page 53, clause 15, field verification.
Page 50?
53, clause 15, field verification.
But there is nothing on that.
Therefore, that is why I submitted, Lord. The 90 days comes under the eligibility criteria. The requirement of making up the lacuna, that comes under eligibility criteria. Field verification only says that if the things are not found in
How
proper.
the lease deed will be signed before that date, Lordship? Because the requirement is the lease deed should be prior to the date of submission of application.
Where is that?
Because this is the condition, Lordship.
Where do you get that?
No, that condition has to be understood in the context of the proviso also. Page 29, your lordship will kindly come back.
Mm.
Page 29 says, under the head, the other conditions with respect to offering of the land are as under, then page 30.
That is, Lordship, in page 6, clause F. Page 6, Lordship.
So that will be page 30. Page 30 of the repetition.
6F, Lordship. In addition to the above, and when the advised by the OMC provisionally selected candidate under Group 1 should also upload the copy of any one of the following documents to establish ownership of the land offered for the dealership. The document must have been executed, registered, issued on or before the date of application. And how, Lordship, this lease deed will be rectified?
No, that has to be read in the context of the clause C. And the clause C, this is only a part of the clause C. It is not something beyond the clause C. Because otherwise this will become without any meaning.
Okay. F is in addition to other clauses.
Yes.
F. Now, if you read clause A, then everything is clear.
Land should be available with the applicant as on the date of application and should have minimum lease of 19 years 11 months. As advertised by the respective oil company from the date or after the date of advertisement, but not later than the date of application. If the offered land is on long-term lease, then and there are multiple owners, then lease deed should be executed by all owners. That is there. But what I am on is that this
In
period,
case lease deed is not executed by all the co-owners, such lease deed shall be treated as invalid.
yes, I am in perfect understanding of this clause.
But we are not perfect.
No. What I am insisting on is that the prior to this clause, my lord, there is a proviso added that if for some reason it is found not suitable to the company, then they will give a chance of 90 days to rectify the mistake. I am on this, my lord. And this particular condition is appearing under the eligibility criteria itself. Therefore, my submission is that, my lord, it's a bona fide mistake, my lord. Instead of, because these things got confused. Otherwise, it has fallen from your lordship, my lord. There was no requirement of submitting the affidavit in the annexure 3, annexure 3B. But they misunderstood the things and they acted in that manner.
Misunderstanding of a prudent businessman of a tender clause cannot be a
My
ground.
lord, it's not
It's a judicial
with
review.
respect, my lord, it's not a tender clause. It's only a,
It's a competitive bid.
no.
It's a competition between many a person.
My lord, it is only
It's a commercial proposal and
These
acceptance.
conditions are only a guideline.
Right.
These are only a guideline, my lord. This is an application format where it says that your eligibility will be assessed on the basis of this. Now, I have fulfilled I have competed against the category of defense personnel. I am a retired defense personnel. I have competed against that category. I came out successful. Now, this particular clause, if it is given as such a rigid interpretation, my lord, then the very purpose of this providing the period of 90 days will be frustrated.
Lordship, only one thing, Lordship. When the 90 days will come here, in case,
Where?
in that clause also where 90 days is provided, in case the land offered by all the applicant under group 1, thereafter group 2 is not found suitable or not meeting the requirement, then this applicant under group 1 and group 2, along with the applicant under group 3, who did not offer the land and along with the application, would be advised by the marketing to provide suitable land in advertised location stretch within a period of 90 days. That means it was after group 1 and group 2 has over. If we will not find suitable land, thereafter within 90 days we will ask them to provide in case, Lordship, the land offered by all the applicants.
So still he has a chance.
After
It's correct.
Possibly that interpretation will go against the.
You read this, clearly read this.
In case land offered by all the
In
applicants,
case of land offered all by applicants under group 1 and group 2 is found not suitable.
Yes.
Okay, not meeting requirements. Then these applicants under group 1 and 2 along with applicants under group 3 would be advised by OMC. So if everything is failed, then they will give you a offer. Once again.
Now, my lord, it is only this particular particular selection process only with regard to group 1. There is no in content.
Therefore, they have said if that is there, they will give you a chance later on.
After group.
No, therefore, my lord, the chance if they before giving me chance, if they select somebody tomorrow.
No, in case of land offered by all groups, applicants under group 1, 2 is found not suitable, not fitting. Then the applicants under group 1 and 2, applicants under group 1 and 2, along with applicants under group 3. So this situation if prevails, then only they will come to.
What I am submitting is that in the present case, my lord, apart from the group 1, my lord, there are no other groups.
May not be. So therefore, they have gone in a stricter sense. So when there are 3 groups, everything is failed, then they will give you a chance on that.
No, in that case, now their selection is only with regard to group 1. There is no group 2, there is no group 3. Now,
so therefore, this clause is not applicable.
No, this clause is applicable because I am a member.
Because yet specific condition is that when all applicants under group 1, 2 and 2 is found not suitable, not suitable, then these applicants, who means all the applicants is group 1 and 2, along with the applicants under group 3, all will be given a fresh chance
After 90 days.
to
Now-
give us an offer. Then there will be a new next bidding, offer better land,
now-
which is not fit, but it's a better,
Now,
or then lesser.
now therefore, my lord, if your lordship is holding it like this for a moment, then the argument made by my learned friend that the lease deed has to be executed prior to the date of application.
That is a condition of C.
That's why I said, my lord, the requirement of execution of the lease deed prior, it is not something inflexible that it cannot be cured later. If your clause permits an exercise, that supposing I have given a lease deed, correct in all respect, tomorrow they find that the land is not suitable. Then what happens? They give me an opportunity to execute a fresh lease deed.
No, not in respect of a lease deed which is not conformity. It's basically
No. Perhaps I have not made clear, my lord. I have given a lease deed, which is, as per them, it is valid. But on field verification, they find that the land is not suitable according to their demand. What they do, they give me another chance to find out a suitable location.
no.
and
They will have to fail in that location from everybody.
Yes,
1, 2, and 3.
yes.
They have no other option.
Yes.
So they will give us a separate land. This land is not suitable for us.
So in that circumstance, the very brochure permits them for a fresh execution of a lease
But at a
deed.
different stage. But at a different stage. Not at the stage when your document is not, lease is not properly executed. They will go to the second stage.
My lord, it is in the very eligibility condition where my lease deed has to be assessed. It is not that the second stage is visualized and thereafter it will come, because this clause has come prior to the clause of field verification.
Okay.
It has come prior to the clause of field verification. Therefore, my lord, my submission is that this particular clause permits them to take a lease deed into account, which if they find that the prior one is not correct as per their requirement, they can give me this chance. I am only asking for this chance. They give me the chance.
90 days.
Yes, I am only asking for this chance. They give me this chance. I can execute the deed, because the parties are all in agreement. There is no dispute, and I have leased out only a part of the total parcel, which is not also beyond my entitlement.
Okay, we'll pass this order. Yes, next case, yes. We'll come back. We'll come on exclusive by the family member.
Yes. Now,
So you want to say by virtue of lease, they have become your family member.
no. By virtue of the lease, I have
By virtue of the lease, you have become the owner of the land.
I have become the
Owner of the land.
far as-
So their family, the
No, no.
family of the lessor is becoming a family of yours.
No, not that.
Then?
By definition of own, I have become the owner on the strength of the lease.
Lease, understand?
So I only step into the shoes of the
Okay, fine.
lesser. And that is why, since there are other co-partners, so that is why the requirement that the other
Co-partner of whom?
co-partner of the co-owner.
Co-partner of the lessor.
Yes. So
that's what we have changed. Co-partner of lessor.
lesser.
Therefore, according to you, moment I entered into a lease, I have, in terms of this contract clause, I have become owner.
Yes.
So since I have become owner, they have become my family members.
No, I don't say they have become my
That
family.
is the clause.
No. The clause says that in the lease deed, all the co-partners should also
See,
join.
clause B, let us read clause 2, M2.
Yes.
There are two situations. Group 1, this is specifically prescribed for group 1 self.
Yes.
Okay. So self evaluation owned.
Self with members of
First
family
is self. Second is self with members of family
or
own exclusive by the family members.
so I don't come in the second category.
Then you come and under which category?
Then please come to clause 3 and 4.
Okay.
Clause 3, self with other owner.
Self with other owners.
Other owner.
So according to you, you have become self
With other owner.
other owners.
Other owner.
Okay.
It is also evaluated as own. And there is also a consent letter requirement of appendix 3. The other thing, that self with family members and other owner. It can be self and other owner. So in
Okay.
every circumstance, my lord, it is evaluated as own,
Hmm.
and the requirement is appendix 3.
Okay.
So appendix 3 has gone there.
Hmm.
Only mistake that has remained is that instead of merely signing this appendix, fulfilling this criteria of appendix 3, they also ought to have been joined with the district. So that is the only area of effect
Okay.
that could be clear.
My lord, I am by party of lease much,
Hmm.
long-term lease much.
How did they give that file? How do you respond to the clause?
Under M, my lord.
Under it.
Under M, my lord, there is no mention.
No M, forget about the M. Come to clause 6A, the second part.
But I have not connected this one.
So we'll help you. Check this. We are here to help you.
Well, I have,
You are a lawyer.
I have, my lord.
We will have to help you.
I have, my lord, but page number, my lord.
No page number is not required. You tell it from there. You have it. You don't have a copy for the judge. Isn't it? Judge will know from the heaven. Yes.
So, my lord,
Read it. Read the clause. Read the clause. Read the clause. Clause A.
my lord.
Page 5. Bottom.
Yes, my lord. The land should be available with the applicant as on the date of application and should have minimum lease of 19 years and 11 months as advertised by the respective oil company from the date of or after the date of advertisement, but not later than the date of application. If the offered land is on long-term lease and there are multiple owners, then lease deed should be executed by all co-owners of the offered plot. In case lease deed is not executed by all co-owners, such deed shall be treated as invalid. So, my lord, in my lord land, my lord, there is no co-owner. I am the exclusive owner.
Where is that?
Leaseholder, my lord.
Then why is the other co-owner says that we are the pattadars? What do you mean by owners and pattadars?
This is their, my lord, defect, my lord. It is not clarified if they are in their, my lord, this brochure, my lord. But they are, my lord, in the impugn order, my lord. They, my lord, how, my lord, they pass this order, it is not clear. Whom are, my lord, treated, my lord, co-owners of my lord, lessor. But this prima facie, my lord, I have annexed one document, my lord, that page 33, my lord. Other co-pattadars, my lord, categorically given the no objection that, my lord, this, my lord, leaser has land of 2 kata 8 lessa, my lord, along with, my lord, them, my lord, and there are, my lord, total 2 bigger 9 lesser lenders there, my lord, and this their affidavit should be treated as no objection.
Where is the provision of giving no objection?
Yes, my lord. This is again, my lord, given this under, my lord, M clause 3, my lord, consent letter. So it was, my lord, my submission is not that, my lord, if it is long-term lease, my lord, it is not necessary.
That's all?
Yes, my lord.
You want to add something?
So, my lord, yet, my lord, therefore, my lord, this is, my lord, there, my lessor has co-pattadar, my lord, this is
Has
their,
given no of this.
yes, my
And there is a difference between co-pattadar and owner. Owners, co-owners are not co-pattadars are not co-owners.
it's not clarified.
Patta is different, co-ownership is different. This is your argument.
Yes, my lord. And my lord, this is where the imaginary, my lord, ground taken, my lord, that, my lord, my leaser has, my lord, co-owners, my lord.
There is, since apparently pattadars are, joint pattadars are not joint co-owners, therefore they have committed a mistake. This is your argument?
Yes.
Yes. Yes.
apply.
Yes.
My case is a bit different in the sense that I was given an opportunity
Mm.
to rectify the defect
Mm.
within time.
Mm.
I could not.
Mm.
Thereafter, my candidature was cancelled. But in the same letter, it was asked that if I have any grievance, I may file a representation within certain time. I represented before the authority and uploaded this requisite document. But in the meantime, after 2 days, they have notified the day for draw plot. Here, Lordship, please to see page 24.
Yes, Roy, have an instruction as to what happened to his representation. Yes, Mr. Das at two.
I
take.
Huh?
Judgment, my lord, June 22, that royalty cases. Also directed that payment should be released forthwith if there is no petition second. Now find out the services are not complete. Although there is 5/2/24 order, our Borpujari's name is mentioned, but that is not correct. He said, "Madam, I have
Okay.
engaged."
Okay. Okay.
And second concept, my lord, nowadays, my lord, we are taking steps in the month of July
This is item number
44.
44.
Same violation, the 22 order.
Now, who is this?
Well,
Yes,
it can be
anybody
tracked,
from.
my lord. It can be tracked, or if the PWD, my lord, if it is there, they can also take.
Okay, let Mr. Dhar be here, Dhar or somebody, Mr. Nayak.
But they were also hurt in the matter of the concept.
Yes, we'll look into this. Where is
Nowadays, it is tracked, but it doesn't come.
no track, but in contempt there are certain problems.
So let them take it.
Sometimes sometimes it has been received by some peon. Sometimes it is the officer is not there. He has been transferred, refused. So that's there. So he is not here. We'll see after some time.
I'll inform him in the meantime.
You inform him. Same. Yes, Mr. Nath.
No, my lord, regarding my lord, this is regarding my lord, bank account of my petitioner's bank account, my lord, has been held up.
Why?
Because there are some loans on that account, my lord, and from that savings account, loan was deducted, but lost people find page 21, and there is a letter written by the manager, the bank, saying that there is outstanding balance. That I have already, my lord, instructed the bank that may be deducted from my account, savings account. But that is my salary account, man. They have, in the meantime, they have held up the account. They are not allowing me to operate the account.
Who is representing the bank?
Bank, my lord, I have respondent number 2. I have already served notice on Dusty, my lord. On earlier occasion also, they are deducting the loan account
Mr.
from
Counsel, before going to the fact whether we can pass an effective order today in their absence, tell us that.
No, that may not be, but my lord,
If that may not be, why are you wasting time? Let us see whether notice is properly served or not.
it has been served, my lord. That's-
Where
I
is that?
submitted the
Where is
affidavit,
that
my lord.
notice has been served? Where is the signature?
I've submitted the affidavit, my lord. The chief manager has signed and received it.
Heard Mr. S. Nath, learned counsel for the petition. Pursuant to this court's order dated 12/1/2024, the petitioner has served notice upon respondent number
2
through Dusty. Full stop. An affidavit has also been filed in that regards. Full stop. The notice, original served notice annexed with the petition reflects seal of UCO Bank, Soraitholi branch. Full stop. In that view of the matter, the notice upon respondent number 2 is complete. Accordingly, release this matter next week.
And
We'll see. No, we're not fixing a date. Next week it will come.
Okay.
Because this bench is only for 3 days. That's why we're not fixing. Yes. Yes. Hmm? No.
Along with item number 25.
List this item number 25. Item number 25. List this 25 and contempt together, huh?
Yeah.
List this later before any other bench without.
Please, your lordship. As per Lozima Court order dated 19 February. As per Lozima Court order dated 19 February 2024, the service has been completed upon 6.
Service is completed.
Upon respondent number 6, but service has not been completed upon the number 5.
The learned counsel for the petitioner submits that in view of the Lawajima Court's order dated 19 to 2024, he may be granted.
That's the service. Within
He may be permitted to effect service upon respondent number 5 through Dusty. Prayer is allowed. However, same should be routed through the registry and an affidavit be filed there. List of the courts.
Time for the respondent.
None appears for the petitioner on call. None did represent the petitioner when the matter was called on 10/12/2020. Full stop. Accordingly, however, Mr.
SP Gwala.
SP Gwala is present representing the railways. Railways. Full stop. The writ petition stands dismissed for non-dismissal.
Obliged.
Yes.
My lord, ASPC in the year 2006 invited a tender for settlement of license for running business shop stalls at ASPC station campus room. That is at page 11.
Now what happened here? There is no stay order.
Well, thereafter I paid the amount for 2006. From 2006, they keep on saying that we will construct. They have not constructed, but they have taken 20,000, 25,000 also. 2007, there was another tender. Well, we file there also we have filed our representation saying that you people has allotted our shop earlier also. Now again, you have taken money from me. Neither you have returned the money, neither you have constructed. Now you have again gone for a retendering of that. And there also one of the petition has participated. With
Where is the tender?
Second one, my lord. Second one is at page.
No, tender under challenge.
Tender under challenge, that is the second tender, that is at page, my lord.
Annex 4. Where is that tender?
But I'm picking for that. Well, terms and condition page 21. At page 20 it starts. And it's the page 19. Notice inviting quotation or short tender.
Okay, now this has not been implemented.
Well, this has
You
been-
are still there.
No, my lord, 2006 we have paid amount.
No, understand. Your grievance was that you have taken money from us, you have issued a tender.
Tender.
Now, do you say that after this,
This
any,
they have allotted up to others.
to whom?
To others, my lord, the other
Not to you.
not to.
Did you participate?
My lord, one of them has again participated.
Huh?
One of the petition has participated and stated therein that earlier also I participated and deposited the amount along at page 30.
No, Mr. Rajputri, what is the challenge in this report?
Repetition, the challenge is this, my lord. This is the government policy for inviting notices to tender. They have taken money from me. But they are arbitrary to that extent that after taking money, they have not constructed, because the earlier notice inviting tender was that they will construct after taking money from us and they will settle us there. But they have never constructed, but they have taken the money. Then in 2017, they have taken issued tender. So when we have said that earlier tender, our money was there, you said you will construct, you have not constructed.
Was there any stay in this tender?
No, the second one.
Then what happened to the second tender?
Second tender, they have allotted up to others.
So whether those shop owners are before this court?
So those are not.
So then that is what asking, what will you do in this petition today? Or for a thing tomorrow, day after tomorrow?
From 17 till today, they have not filed affidavit, neither they have said it. But they have kept silent over 17 to 24. Not a single affidavit, neither denying. And if there is the order,
Now what kind of order do you want from us?
Subject to it, at least
To set aside that,
No, my lord, I am not
to set
asking-
aside an advertisement.
money that petitioner has paid, they should refund this money to
Is it a subject matter of the petition?
ultimately, because here what we have stated that they have acted early arbitrarily. They have taken money from us and they have kept silent. They have done nothing. They have acted absolutely arbitrarily. It is a fact they have taken money and they have allotted money shops to us. But they have not constructed any shop. After 2017 only they have constructed them. And 17 till today they have not said, denied anything. And the first order was subject to outcome of the writ.
To do with this petition? Mr. Rajputri, I need not tell you anything. You are a seasoned counsel. If you argue on this, kindly come to your prayer.
That I have.
If you appreciate,
but I
give us some handle to pass an order. You are sleeping since 2017 when you did not get an interim order. Now you are saying that give us the refund money. Under what authority of law, without there being any pleading, without there being any prayer, we can pass such an order today?
But only
your challenge is see. 15/7/2017
Yeah.
tender is bad. Okay, set aside. Then you say on the basis of 15/7 tender, give us this shop to us.
Well,
whereas you say the tender is bad and set aside the tender dated 15/7/2017.
there was no
Now what relief we can grant you?
only because Ballot, your lordship's power is
Since you are saying because we are deciding.
Ballot, your
If
lordship's
it is not expected from you. Yes, or good.
because your lordship's power is
We'll now keep our mouth shut and we'll decide.
only thing is that your lordship's power is wide enough.
Yes,
Only thing
our power is wide enough. Then so
only that
issue a writ of mandamus directing an allotment of a SEP
no, but I'm not asking allotment.
or issue us the directive to refund the money that you have.
At least with the consideration, Ballot, that money which was there with them, they have done nothing.
Is it not a subject matter of this writ petition? There must be some semblance. It's not that we'll always go by the prayer. We can mold relief. We understand.
That much was my thing. That was my prayer before.
Heard Mr. P.K. Rajputri, Planet Council for the petitioner. The present writ petition is filed. assailing an NIT dated 15/7/2007. It is the case of the petitioner that pursuant to similar process of tender initiated in the year 2006, the petitioner applied for allotment of soft stalls within bracket second phase at ASTC campus in Rania. Full stop. According to the petitioner, the MD ASTC under separate communications in 2006 allotted space number 29, 27, 30, 46, 31, and 28 to the petitioners and directed them to deposit non-refundable registration fee. According to petitioner, the ASTC promised that construction should be completed with the money advanced by the petitioners, but since 2006 till 2017, no construction was made, and instead of constructing and allotting the shop, the petitioners allotting the shop, the tender was initiated. Full stop. This court, while issuing notice of notice, did not pass any interim order stalling the tender process. Full stop. Mr. Raisaderi submits that pursuant to the tender notice dated 15/7/2017, impugned in the present writ petition, other persons were allotted the aforesaid shops. Full stop. Those allottees are not before this court, and this writ petition is pending since 1/11. This is pending since 2017. Full stop. In that view of the matter, in the considered opinion of this court, so far relating to the tender, nothing to be, no cause of action survives to be determined. Full stop. However, accordingly, the writ petition stands closed, being infructuous. However, so far relating to the grievance of the petitioner, that money were they advanced money, and the ASTC promised them to allot houses and However, they did not allot the not houses or shops. Shall remain open to be agitated by the petitioner, though this writ petition is closed. In fact, you file a petition now. Whom will you call? You have not repeated. You have not amended the writ petition. We can do nothing. Still, you can do if you want. You do it.
All right.
By this petition, I have challenged the order passed by the railway authority directing me to deposit rupees 9,58,000 as a maintenance charge losses for a railway level crossing. Annex 4, page 25.
Yes. My lord, this is a case where initially I thought of filing an affidavit, but the documents are almost there. So the only question is, this level crossing is catering the need of the institute only, and railway is not inclined to maintain it. So the question arose whether they will maintain it at their cost or we will have to close it. Otherwise, my lord, if your lordship goes to the Railway Act, if any line crosses to a railway, and if the state government
will examine this, admit issue rule, call for the records. As the parties are duly represented, no press notice need be issued. Please this matter for hearing in its usual court. Interim order passed earlier
2017 month.
Shall continue. Okay. Have the gate for railway. You are maintaining many things in the world. Till we decide.
Okay.
Yes, but
The case, your lordship, payment of contractual value, your lordship, but is
COVID. Already you are time barred.
No,
You ought to have, after filing of the affidavit, you ought to have said that I'll go to civil court.
No, your lordship may kindly see one thing. They have not denied it. Your lordship may kindly come to the affidavit. Your lordship.
What more denial is
No,
required?
your lordship, what
They have said there is no work order, no supply.
no,
Show us something that you have handed over to them.
but before that, your
Where is your reply?
Para 4, your lordship may kindly see there.
Yes.
They have what they say. That as regards the statements made in para 4 and 5, the answering deponent begs to state that statement made in this paragraph are incorrect. Document which is enabled is not a go-ahead order. They are not denying the existence of the order. It is only procurement letter. Now, what is the difference between your lordship procurement letter and the go-ahead letter? Letter we written to the Director of Health Services BTC to control the spread of COVID-19 in BTC area. In this context, there is a clear report from Director of Health Services so-and-so, dated so-and-so, which is not approved by the higher authorities, competent authorities prior to issue of the go-ahead order. If the answering further states that that's not required. Now, your lordship will kindly see, they have not denied the existence of the letter. They have not denied that they have not received the materials, your lordship. The only thing is that approval is not there. If approval is not there, that cannot be my fault, your lordship. And they have not taken these officers to task, your lordship, for that. Ultimately, your lordship, for this, can the petitioner suffer? There must be a
I
denial.
understand, but it's a read court.
Lordship,
They are saying we had a committee, we have examined, most of the supplies are not there. You have a work order, you have delivered it somewhere else, nothing on record to have a prima facie satisfaction. Where is your reply? That I have supplied to this office on such and such that these are the received.
I have annexed, your lord.
Where is that?
Lordship will kindly come to my read. Para 16 is the, your lordship, the decision, your lordship, to procure. Then your lordship will kindly come to para page 19. With reference to the subject.
Yes, where is BTC? Who is your senior? SR Ahmed. Rabha. Call him. We want the record on the basis of which you have said the supply record that whatever you say, you made a specific statement that documents whether you accept or deny. Call him.
And in fact, your lordship, for a moment, your lordship takes up page 22, your lordship will find. These are your lordship. We have deposited, your lordship. This is the signature of the pharmacist, your lordship. And after receiving it, your lordship, we have.
This is the problem. You'll have to examine the pharmacist to the witness box.
No, your lordship.
Is not it?
No, they have not denied that.
Okay, let us see. Therefore, let us have a specific stand on all these documents. Because their affidavit is evasive.
Evasive.
Yes. Let us make the specific things that what they need to hide. Let them come.
Oblige.
You also had the COVID benefit.
May I please?
Yes.
My lord, the matter relates to, my lord, therefore direction, my lord, to pay additional ex-gratia amount, my lord, of rupees 2 lakh for the petitioner, two brothers. Father and three brothers, my lord, were killed by accident in the year 2000.
What is this? What is their stand?
Page 19.
What is your basis of your claim?
Basis of my claim, my lord, by notification, 2013 notification, my lord. Earlier it was paid 1 lakh rupees. Now it has been enhanced, my lord, by notification 2004 and 2013.
When your person died?
In the year 2000.
In the year 2000.
Then, my lord, 1 lakh it was.
Then it was 1 lakh. Okay. Then when it was paid?
It was paid, my lord, in the year 2000.
In the year 2000 it was paid. Now?
And now, my lord,
then?
Well, things developed, my lord, matter, my lord, came up before this honorable court. But because there was a service provision, service bond, my lord, and then rupees was enhanced. Earlier rupees 1 lakh and service was. But when the policy, my lord, it is now gone, my lord. So 2 lakh rupees, my lord, enhanced. Then, my lord, we have
2 lakhs when?
2 lakhs, my lord, 2013.
2013. Then?
And then, my lord,
you wanted 2013. 2 lakh. Under what right? Which gives you the right to claim after your payment is made? Is there any provision that those persons who has paid only 1 lakh will now be paid after payment of again enhanced? Where is that?
My lord, kindly see page, my lord, 23.
20?
23, my.
Yes.
Then, my lord, clause 3, my lord. Enhancement of the ex-gratia amount paid to the next of kin of a person killed in extremis violence to rupees 3. This enhancement. This is enhancement. Earlier it was 1 lakh.
We understand.
And then 30, page, kindly see, my lord, page 34.
Page?
Page 30.
30?
34, my lord. 34, my lord, the High Court case, my lord, reference is given here, my lord, on the body. Then 35, my lord,
35?
35 relevant, my lord, clause 5. Clause 5.
Okay. So what are the conditions? That died prior to 2004, but did not apply prior to 22nd June 2004. But you have applied.
My lord, that is.
Okay, this is the first condition and applied after 22nd of June 2004. So your case is not covered.
And may or may not have received ex gratia
So
under 2024.
understand
all
you,
covered.
but first condition is that you must person must be clean prior to 2004, but you did not apply prior to 22nd of June 2004 and had applied after 22nd. Where is the issue is your condition that you have applied prior to
My lord,
2004?
talking about 30.
Huh?
30. This is my lord service. Now, kindly see High Court order.
Huh.
My lord, page 32, paragraph 12. Page 32.
Paragraph?
Paragraph 12.
These are the cases where nothing was paid. Is not it? These are the cases where nothing was paid. But there is no proof that now suggests that applications were made after the second policy 22 to 2004. But in your case, 2002 itself you got the money.
1 lakh.
Whatsoever, you got the money. What was the at that point of time amount was how much?
1 lakh, only 1.
1 lakh you have got it.
But
Now
once
can you
service policy, my lord, has been
not
repealed.
been given
Then
in
2 lakh.
2001? You have not applied. We have not challenged that I have not been given.
My lord, cases, sir. Here, my lord, similar order, many orders, my lord.
No, similar order must be justified with law. We are bound by ratios, not by case.
And government has filed affidavit also, my lord. They have relied on 2013 notification. They have not opposed it, my lord. Lord, it's 5 and 6. 5 bottom, my lord. Accordingly, my lord.
So that notification came in 2004. By that notification, it was made 3 lakhs. So that notification was made effective not only to those persons who died on or after 22nd of June 2004, but to those persons who died earlier. Is that it? 2004. What are the conditions? Not to all. There are some conditions. What are the conditions? Whose relative did not apply for any appointment prior to the 2nd June and then applied after 2nd June 2004.
So, my lord, we did not apply for any job.
But you have made an application under 2020 earlier. But when you got 1 lakh?
Earlier, my lord, it was a massacre in the state, my lord. It was from the own of the government, my lord. Pendency page 19, my lord. That is the order, sanction order, my lord.
You are happy with this kind of orders, Mr. Gogoi? I do not want to invite a contempt.
And my lord,
I do not want to, on the prayer of the learned counsel for the petitioner, matter stand judgment. And be list after 10 days. Your has died 2002. There was a scheme of 2004. Then 13. Now you are coming to the court in the 2020.
Things are being processed here from the government side.
So we decide
because inquiry, verification, examination required by law. They are
The thought is there.
It's a door, right? That RCN construction service is complete so far relating to PWD, but none appears. So we said that you go through it. You can appear, I think, for PWD.
I can.
Okay.
I will just pray for my lord to copy so that
Copy? Give a copy. Mr. Dhar submits that he can appear for the all the respondents for respond. You can appear all this departmental commissioner and appear on the and however he requires some time to respond to the contempt petition.
provide.
Prayer is allowed. In the meantime, the petitioner shall provide extra copies to Mr. Extra copies of the contempt petition to Mr. List after 3 weeks. You have it. You
45
45 and
45.
44 and 45.
My lord, just my name should be
Registry to reflect name of Mr. R. Dot in the cause list representing the respondents.
I'm for my private respondent number 10. I have filed affidavit in opposition.
29.
20.
2. 9.
And my lord, the fishery was settled with me.
None appears for the petitioner and call. Petitions that 1 year. Yes.
No, my lord. No, my lord. This is my lord 50% fishery, my lord.
Understand, but otherwise, you are the society.
Yes.
By the that what you call it fishermen.
Yes.
Fishermen's Cooperative Society. They have quoted rate for like 50,000 for the whole, and you quoted every year 21, 20, 20. So his bid was rejected.
Under the amended rules, my lord, rule 12, my lord, it has to be settled with the register.
Anyway, so we are dismissing it for default. They are not after it, this affidavit filed by who filed this affidavit? You have filed.
Yes.
So you have brought everything, nothing dismissed for default. Mr. E. Islam is
Respondent
present
number
representing respondent number. Yes.
So the case for non-payment of conflicted dues, your lordship, they have filed an affidavit.
Yes, yes. Can it be a ground for non-payment? What is this?
You have not admitted the whole.
Whatever you have admitted, pay him.
No, Lord.
What is your affidavit?
Page 33, Lord.
Page 33. What do you say? Tell us.
Lordship, these are flood management program.
Kindly come to paragraph 8. Who will pay the fund?
Lordship, the fund was divided between central government and state government. Central government is to pay, state government part is complete, Lordship. Central government part we are not receiving.
Who is the central government? Which one is the department?
Lordship, Jal Shakti.
Jal Shakti. Who represents that?
CGI will represent.
Huh?
Central government advocate.
Yes, anybody Union of India, any officer is made party?
No, Lord.
No, that we understand. If they say that we have done our part, others is not there.
Similar method, I that my method is but about 80% there is owned by the central government. 20%.
So your problem is this: state is not releasing their part, therefore central is not releasing.
No, the state they have released their part.
Yes.
To my affidavit, as per their affidavit.
Okay.
We have filed it today, Lord.
Used to appear, like it. But they have filed their affidavit. They have said that possibility of fund as the central
No,
government.
here is also same. This affidavit by whom in your case? By the state. They say that we have done our part.
Earlier, a series of petitions were disposed of by the Honorable Court, directing them to release the fund for 6 weeks. My case, that order I have.
So therefore, we want R.K. Dev Chaudhary. Forget about whether it's made party or not. Where is R.K. Dev Chaudhary?
There will be a problem if central government does not release it. This order, Lordship, then they will only file contempt against her. So, Lordship, they should be made party in this.
They will make parties. We'll see. Let us have Mr. R.K. Dev Chaudhary first in a court. Where is he? Call him.
I have
Wait for a second.
31 and 53 also.
3153. Repeat. Just verify whether Mr. Dev Chaudhary is available in the town, and if he is, call him at 2. We'll see what we can. None appears for the petitioner on call. The present writ petition is filed with a prayer with a grievance that excess fare amounting to rupees 38,99,955 were received against 42 wagons were received by the railway authorities. However, only 38 wagons were made available to petitioner by the authorities. And accordingly, it is the case of the petitioner that petitioner is entitled for refund of the freight. The railways have filed an affidavit and raised a question of maintainability of the present writ petition, in as much as it is the case of the railways that the alternative remedy, there is an alternative remedy available to the petitioner to raise such grievance before the Railway Claims Tribunal constituted under Section 17.
Yes.
Or considered under? That is yours then. Constituted under Railways Act. Be that as it may, as none appears for the petitioner on call, this petition is dismissed for now. नाम तो लिखित होना पेज but MS K Fukan is operative for present representing or representing the railway. Yes.
My lord, in this case, I have received the instruction, my lord. I could file affidavit.
Learned Standing Council for the
Panchayat and rural level.
PNRD department prays for and is granted 3 weeks time to file affidavit.
What? Quick.
2 weeks time to file affidavit.
Oblige.
Why have you? What is your instruction? You have
Instruction, my
given
lord,
false
as per my instruction, already listed, my lord, released, my lord.
release.
My instruction is that, my lord.
Okay, let
That
them
is why,
file.
affidavit wise, my lord.
You proper file and project. This is released. The house as a
Yes.
constructor or
My
something.
lord.
It's
Annexes
so
are also there.
that- okay, he can rest. Yes.
Oblige.
Maybe in this case, I will file affidavit.
What affidavit will you file? Yes. What is your grievance? You want a cancellation or mutation is his name. Do you know there is a act or regulation called Assam Land and Revenue Regulation? Huh? What affidavit can we decide? What is the provision under Assam Land and Revenue Regulation? Learning Council for the respondent prays for and is granted 3 weeks time to file reply affidavit. List after 3 weeks.
In these 3 cases for my friend Pratik Malik, there is a Dasti service in respect of registered and Dasti in respect of respondent number 3 and 7. 3, he received it, and 7, he declined to receive the Dasti on the ground that he already received the registered. And my affidavit is there, my lord. My lord.
What is your grievance?
My lord, grievance, if your lordship look at the last order, my lord.
Last order dated?
Last order dated, I think,
13-2.
Yes. My lord, it is like your lordship be aware that one thing.
You could not drop your tender within time.
Within time.
Now, how will you decide that there was?
No, it's from the report only it will come up.
Where is that report?
The report is there in the today the file. Affidavit.
Today I have filed the affidavit. In that affidavit, I have connected.
What is the what is your report says?
Report says, my lord,
report filed by whom?
Deputy Commissioner.
Deputy Commissioner.
What is the report says?
My lord, first point, my lord, that is the page 94, I suppose. First, in the context above following were the first condition, my lord got it. Entire case is over there only, man. My lord, I never heard in last 27 years that tender box is placed and there is some kind of a process. Because of that, till 1 o'clock, no tender was allowed to be dropped in the market. And I believe, my lord, almost all the friends sitting behind, they have also did this kind of cases. If anyone could say that yes, there is some kind of a processing.
For that will require something here. In the behind.
I understand, not required.
That will.
Here.
So let us confine to the first the report. If you want to respond to the report, that is a different issue.
What I'm saying first, let us.
Sometimes our experience cannot be a basis of judicial review on the in exercise of power under Article 220. That is the difficult. We have many experiences in life. We know many things, but we cannot make decision on our personnel.
It helps, man.
It might help, but we cannot take decision.
Correlated, man.
Yes.
Only thing first, before going to the affidavit, if your lordship pleases to this.
Are you going for final disposal?
No. I received it just now.
So tell us.
So
that's why I said if you want to respond to that, whatever you have stated that this is not an absolutely perverse, non-believable inquiry report. That will have to bring on an affidavit.
My lord, only thing is that this regarding this dusty may be completed.
That will go. Let us see the dusty affidavit.
Dusty affidavit is there, my lord.
No, we'll go through that. This is inquiry report.
No, dusty service, there is an affidavit in itself, my lord, in the month of September 2023. I think that is flagged A by the my lord God. Regarding the registered part, there is a tracking record, but only regarding the dusty, they did not receive from me. In all the three repetitions.
Heard. The JABD, Learned Counsel for a Petitioner, also heard Mr.
MAI Hussain.
M.E.
MAI Hussain.
M.A.I. Hussain for the
Respondent number 8.
respondent number 8. Yes. You are for standing counsel? Which respondent? Dr. Appears for. You are Mr. M. Setia for respondent. This court, under its order dated 11/8/2023, allowed the petitioner to take dusty service, to effect service upon respondent number 3 and 7 to dusty.
Through registered and dusty.
To registered and dusty. The petitioner has taken dusty service routed through the registry of this court and also have filed an affidavit. Peruse the affidavit as well as the notice served upon the respondent number 1. Respondent number 3. This is number 3, which shows that where is the original? It is with you. That service of notice.
Yes, yes.
It should be annexed there with. Isn't it?
I think
you have annexed the Xerox copy.
There, on 31/8.
That is why that is with you.
Yes,
that should be part of
the record.
That is why it is been returned to you. Which was duly received in the office of the Darang Jila Parishad. Full stop. Mr. Abedin, the Xerox copy of the said service said receipt is annexed, though Mr. Abedin has produced the original. Full stop. The original is kept on record. You want a Xerox?
No, I have
the original is kept on record. Original produced by Mr. Abedin is kept on record. Registry to keep the same. Okay. The notice in respect of respondent number 3 is accepted. So far, relating to the respondent number 7, a specific statement has been made that the respondent number 7 has refused to accept such notice on the ground that he has already received the notice to register post. Be that as it may, as the petitioner and the respondent number 7 refused to accept the notice is deemed to be served. Accordingly, matter is ready as regards service. Place this matter in the admission column.
After 2 days.
After 2 days?
Yes, because already 8 months
okay,
gone.
Next week. Next week. In the meantime, Mr. Abedin may respond to the inquiry report, which has been inquiry report which has been brought on record by respondent number 8 pursuant to this court's order dated 13/2/2020. Please, Deepan.
My lord, the order will follow in the other two repeats.
27. Both all will follow? Same?
Yes, same.
Same respondent numbers is also same?
Exactly.
What are the repetition? And there also inquiry report submitted?
Yes, same.
Yes.
Same inquiry report, my lord.
But you have filed in all cases?
Covered all the cases.
Okay.
No, he filed only for this.
Okay, anyway, that will see. What are the other matters? 54 and 50.
54 and it will cover.
Same one.
But the order will be in 54 and 55 also.
Yes.
They are personally present there. They have interviewed them. But my instruction says 2019. They were also present. They visited. My instruction was that they were visited there.
Date was given in 17th. Date on 9th.
Okay, we'll come to your just a minute. So the Mr. P. Silas, Learned Senior Counsel, assisted by Mr. Stone, Learned Counsel, and Mr. S.S. Learned Counsel for the respondents. The grievance of the petitioner is that the petitioner who participated in a tender, or what we call it, notice.
Notice.
In a proceeding.
For selection of RO
participated in a proceeding for selection of
retail outlet
within bracket petrol pump dealership. In the process, the petitioner was requested by the respondents by its communication dated 17/1/2014 to 24 to upload certain documents, rectified documents
by
17/2/2024. However, the petitioner could not do the same by the date fixed, that is by 17 to
because I was busy by
2024, as the petitioner was busy with
his marriage ceremony.
You'll be happy with your wife. Why you need a petrol pump? Huh? Okay, full stop. However, the petitioner has subsequently made a detailed representation.
So they cancelled it at page,
and accordingly, candidature of the petitioner has been rejected.
But
Being
he was
aggrieved,
given,
the petitioner preferred a representation.
he was given time in that case.
17/2.
79/2, page 24.
So 9/2, that is it. What is it?
Plus 5.
By 9/2/2024, your candidature has been rejected.
Yes, rejected.
Okay.
But I was given
9 till 17/2/2024.
Yes.
Yes, Mr.
Lordship, 9th February 2020.
What is the 17/2?
72 they have not
It is my representation.
Huh?
72 is my
after 19th Feb it was given up.
You may make your representation by 19th February. We made it on 17th.
72 they have not annexed.
No. Forget about that. You were given time till which date?
19th February.
19th February. Where is that communication?
This is page 24.
Page
24.
Page 24.
Plus 5.
This was a letter from Mr. S.S. Roy's clients to you.
Yes.
Isn't it?
Yes.
Saying that
My candidature has been rejected.
no, where is that?
And if you have any grievance against this, you can file a representation by 19th Feb 2020.
Plus 5, paragraph 5.
In case you have any grievances against the rejection of your candidature as mentioned above, you
Where
may
is
make.
17/1/2024?
They have not annexed.
Page 21. 17 or
Yes, the 21, page
page
21.
21.
You were given granted time till 7/2.
7/2.
And you have filed a representation when?
17/2.
And when was your thing was rejected?
7/2.
On 7/2 itself.
9.
9/2. That is what I am asking.
9.
I'm correct then.
Yes.
Yes.
I'm correct.
Yes.
7/2 your last date. 9/2
Rejected.
after
Rejected.
7/2 is over, 9/2 rejected.
Rejected.
Then 17/2 you file a representation.
Yes. But therein it will say that I can file a representation.
Yes.
That's why
that we are coming. First, let us correct the first fact. পাগল কিনে বিলাক confusion. By
It will be 7.
7/2.
7.
By 7/2 2024. However, admittedly, the petitioner could not file such rectified document by 7th of February 2024.
Yes.
And accordingly, by a communication dated
9th February.
9th of February 2024, the candidature of the petitioner was rejected. Okay.
Was found ineligible.
Was rejected
As ineligible.
Being ineligible. Full stop. However, by communication dated 9th of February 2024, an option was given to the petitioner to file a representation if aggrieved by such decision. Accordingly, the petitioner preferred a representation on 17/2/2024.
Yes.
And the grievance of the petitioner is that such representation has not yet been disposed of by the respondent. Full stop. Mr. S.S. Roy, on telephonic instruction, on telephonic instruction from his client, submits that the such representation of the petitioner was rejected on 19/2/2024, inasmuch as the petitioner is aware of such rejection as he himself was present while that representation was rejected. That being the position, let this matter be listed on Monday. You have a copy? Rejection.
But because today I don't have.
And on which date, Mr. Roy? Mr. Roy shall produce. That's all.
What day?
Today is Wednesday. Can it be
Wednesday.
possible on Friday?
Okay.
Friday.
Yes.
Instead of dismissing today, we'll give a copy on date to you so that you can at least say that this is incorrect. I'll file a fresh writ.
No.
Yes, Mr. Datta, what you propose to say? Assuming that we are rejecting your assuming. Okay. That we are rejecting your interim prayer. We'll go through details. Your argument we have recorded. We'll re-verify your arguments with tally with the document. Okay. Now, suppose in the event we decide that we are not inclined to grant an interim. Now, what remains?
In that case, everything will be subject to outcome.
You want that? So in the case we pass an interim order, well and good. That's fine.
Otherwise,
We'll do it immediately. Whatever we do during the course of that, they will do it because you have a lottery tomorrow.
Yes.
Okay. Either way, we will know the result by evening. We'll because only 10 meters are there. We'll dictate right now. In the event we pass an interim order, very fine, no problem. But if you reject it, do you propose a rejection of an interim order or rejection of the whole petition?
rejection of the interim order.
What will remain?
Whole petition will, rejection of whole petition will be, will not be in the interest of the
Okay.
party.
Okay. We are not expressing anything, don't think. Okay.
Their representation was also displayed on 19th.
Yeah, in their case, representation
Is
may
there.
not be very vital because they have argued on
Lot.
merit, and we'll have to, if we reject their interim order, we'll have to answer what he has argued.
Lot.
That's why we are taking some time.
Lot.
And otherwise also, if we grant them, we'll have to address your argument that these are the interpretations. So that will require, instead of wasting the time in the
Yes.
court, we'll pass in the chamber.
The theme of my argument is that it's a flexible. I mean, the
Your
conditions are
your whole theme is that the objects ought to be achieved
Yes.
by these conditions will be achieved in view of the Annex 3.
Yes.
That's all.
Yes.
That is, and
Yes.
you cannot give a rigid interpretation because your object is to get the best man,
Yes,
and
get it.
amongst them I am the best man.
Yes.
Now you'll have to go to the person who is not even equivalent to me. That is your
Who has not come out in the first
round.
First
You are
round.
rejecting a person who is first round. That is your first argument. Second argument is that 90 days,
Yes.
that you ought to have given me a period of 90 days. Third argument is that when it's a owner, self is will in view of the definition will become a owner, and therefore the annexer appendix 3 will suffice the what you saw. These three are the argument.
Yes.
Okay.
And if time is given, then it can be rectified.
So of course,
Yes.
if we pass an interim order, definitely that will examine. If we not, then it's not. Then some in a fine morning that will become infectious. Yes, Mr. Das.
Well, job lot is tomorrow.
That we cannot help.
But
You be happy, go somewhere else for honeymoon. We cannot help in that case. He is even having an arguable case. Your is an admission that sorry, I was busy with my marriage, so I could not do it. Who will wait for you? This is a commercial transaction. And they are very apprehensive. If you can give up such a lucrative project, then after marriage, who knows?
but it requires some money to feed my wife and to
We have doubt.
I have
This petrol pump may be a problem for you. You will not be able to maintain both.
no,
That we have proven.
one information that I gathered from WhatsApp that in the newspaper that wife was told, wife requested to go to somewhere in Abu Dhabi, Middle East. But husband took her to Ajanta.
That is the problem.
And for that ground, after she went to Ajanta, no doubt, after coming from Ajanta, she filed a divorce claiming that my husband.
So you are a failure, not only your family front here also. You miss the target.
No,
Where is,
I am apprehensive of that one.
so you were supposed to go to Abu Dhabi, you went to Ajodhya, you were supposed to file by 7/2, you missed it. We cannot help you. Yes, next case.
Both are inflammable.
Both are in. Yes, Mr. Botagor. Oh, that Mr. You file a specific affidavit. Your affidavit is evasive. What do you say about his statement that it was supplied? There is a committee. You have not responded. Mr. Rabha, learned standing counsel, learned counsel for the BTC, submits that though an affidavit has been filed, the specific stand of the petitioner regarding execution and supply of the work has neither been denied nor been admitted. In that view of the matter, he submits that he may be granted 2 weeks time to file a detailed and specific affidavit as regards claim made by the petitioner. Please accordingly. Mr. You are not a party.
No,
No officer is a party here, but State of Assam in the this department and officers, they have taken a stand. Just see, they have executed the work. This amount is to be given by the Union of India, and therefore we have given our part. This amount remains. Moment Union of India gives us the money, we'll pay it. So you'll have to see where that's all.
No, but I just like to take a WPC.
Union is party.
If your lordship will take WPC 7747.
7747.
No, 7777.
31.
I'll just take your lordship to the judgment passed by 14th bench of this court. At page.
Some conditions. First, you do that.
No. Yes.
4 or 5 stages.
At page 175.
Page 175.
175 of the judgment. Now, what the state is required to do, they have to prepare a thematic budget, pass it in the assembly, and then they have to forward it to the central government, and the fund will be released.
Okay.
That was the condition. How this is worked out. And in this particular batch of cases, lordship,
Is this similar order in your case also? All these cases, same order?
Lordship, but there is dispute in the amount. They have
No, forget about the dispute. We are not on. Do you say that whatever due has already been paid? Is it okay?
from state. We have
We understand from state. There are 2 components. As if we go to the order that says that supplementary budget is required. Then after supplementary budget is approved, this might have happened in this year supplementary budget.
no, it was done in 22 itself.
Okay, so supplementary budget is to be approved. Then you will place it to the Union, Jal Shakti Ministry. Then Jal Shakti will release to you. Then you will pay. This is the procedure, and this is to be completed in a specific period. Okay, we are for the time being, we are saying that this period may not be easy to do all these things.
Only thing the state has to help.
In your affidavit, your stand is that due to paucity of fund, we have not been able to pay. But where is your, as learned DSG has pointed out, where is your stand that you have done 1, 2, 3, 1, 2, and 3?
Lordship, we give the give it to the Brahmaputra board. They forward it to us.
Where is your statement that
No,
you have
no.
done it in terms of distance?
That we have
No, that is one aspect. But Brahma simply forwarded it to the Brahmaputra.
You
board.
do not do.
There has to be a, as it is.
That
pointed
was
out,
what I am taking.
thematic
Where is your
budget.
affidavit?
Lordship, in item number 30.
All the orders are like this only.
Yes.
These stages by the same court. So you file an affidavit. Then we'll
If
Mr.
that is clarified, I can. very
That
well.
you are correct. But we may call you again. But though you are not a party,
No, Lordship, I very readily help this court and the petitioners if they are interested. Lordship may
this
reflect my name, I will.
okay. This batch of present contempt petition, isn't it?
No. In my mail, 31 and 53 is repetition.
30 is also.
Okay, you want a similar prayer?
Yes.
Similar direction. What is your stand?
Lordship, there is a dispute in the amount paid.
No, dispute will verify. We are not paying that amount,
Yes.
pay this amount. Do you say that this order will cover their case also?
In item number 31 and there it 53, that will cover.
So instead of passing an order and to invite them to file a contempt, let us have a continuing mandamus. Isn't it? You file an affidavit.
We have filed our affidavit today, but that part is not clear. Lordship.
Okay.
They have only addressed the amount disputed.
Amount we are not going for the time being. Whatever admitted, have you paid that? That is what we want. We are not going to pass any writ of mandamus saying that determining the dispute whether X amount or Y amount. If you admit X, pay the X. That's all.
Admitted.
For Y, they will go to the civil court. Have claim interest and all whatsoever. We are not giving them anything more than what is admitted. So give me the first writ petition. WPC 7799 and WPC 7777 to 2020 2 and WPC
671.
6715.
715 may not be disposed.
No, we are not disposing any of the writ petition. We are asking something you to do. 6715 2022. Okay, and where is the content? There is no content. Okay. So you want a similar order like this. Heard Mr. N.K. Kolita and Mr. M.H. Loskar for the petitioners and Mr.
C. Sharma for water resource.
C. Sharma, Standing Council, Water Resource Department, and Mr. Dev Chaudhary, R.K.D. Chaudhary, learned DSC. Full stop. The grievance of the petitioner is that they have executed works under water resource, na?
Yes, sir.
Under water resource department. Full stop. Such work is being financed by the Union of India through the Ministry of Jal Shakti. Full stop. However, it is the claim of the petitioners that even after execution of the said work, the petitioner are not being paid. Full stop. The Learned Council for the petitioner
Payment was
not executed, though a part of the amount has been paid. Full stop. The Learned Council for the petitioner further contends that their cases are similar and covers by the order dated 27/3/2022 passed by this court in a batch of writ petitions. Full stop. Level
4734 of 2021 and others.
4734 4734
2021.
4734 2021 and others. Okay. 27 and this court, the Learned Council for the respondent has also submitted that the petitioner's cases are covered by the aforesaid judgment. Full stop. This court, under the aforesaid order, issued the following directions. 178, huh? 1, 2, 3. Full stop. However, it is submitted that such order has also not been complied with till date. Just well recording it. This order, they are also not paid.
So some past payments are going.
Totally complied with by this court. Full stop. Though an affidavit has been filed and it is admitted that an affidavit has been filed by the respondent state contending that admitting certain part of the due and taking a stand that due to paucity of funds, same could not be paid. Full stop. In this regard, the Learned Standing Council for the Water Resource Department further contends that no specific stand has been taken so far relating to the direction issued by this court under its order dated
27/9/2022.
2022 as regards supplementary budget and forwarding same to the Ministry of Jal Shakti. Full stop. Accordingly, he submits that as all the petitioners are similar and the judgment dated so and so shall cover their cases, the respondent may be granted chance to file a detailed affidavit as regards the procedure adopted by them for payment of outstanding amount due and in terms of this court's order dated so and so. Otherwise, nobody will pay. Mr. R.K.D. Chaudhary, learned ASG, also submits that until and unless the direction issued by this court in the aforesaid order dated so and so is followed / adopted by the state respondents, the Ministry of Jal Shakti will not be in a position to reimburse and pay the amount to the state authorities, to the state authority. Full stop. Full stop. In view of this, in view of the aforesaid deliberations made before this court is inclined to grant an interim grant an adjournment to the Learned Counsel for the Water Resource Department, who shall file an affidavit clarifying their stand as regards the procedures adopted, actions taken for the payment of the admitted due of the petition. Please this matter on. Give a date.
One small. The paper match funded by the sector.
Partly funded.
80% and 20%.
Partly funded. Funded, I'll correct it. That came to my mind also 80-20. 80
and 20.
27th. Okay. Register to list this matter showing name of Mr. R.K.D. Chaudhary, ESG. We are passing this all this order together.
But it's not tagged here.
We are passing a common order. This will be a common order in 7777777, 7799 and 6715. This will be a common order. That's why we have recorded your name and his name in both the petitions.
Right.
Sure.
All right.
Instruction is evident.
Huh?
Instruction is evident.
What is the issue here?
Please, my lord, petitioner is apprehended, my lord, they may be evicted from their land, my lord.
We may be evicted at any time.
My lord, kindly peruse order dated 24/5/2023, my lord.
Not without any effect. This, the respondents are trying to.
Who are you?
I'm Minal Kandida.
No, you are who are you? You are the respondent number?
My lord, I am appearing for PTC, my lord. PTC, my lord.
You are appearing for
PTC.
respondent number
2 and my lord, 4, my lord.
BTC 2 and 4. This land is required for whom?
For PTC, my lord.
You have that instruction whether you have taken any. Are you still in possession of the land?
My
I'm
lord,
still in the point. I'm living in the land.
my lord, they are protected, my lord, in 30, my lord, order dated 24/5/2023, my lord. Para 6, my lord.
Para 6.
Our name is already in the land record.
Okay.
We have also obtained the pata.
Okay. MS. You are?
As to appearing on behalf of P9.
Pina. He's here in the court?
Right.
Okay. Mr. Pina, learned standing counsel for the BTC, submits that he may be granted further time to obtain instruction in terms of this court order dated 24/5/2023. Also, prayer is allowed. List this matter after 3 weeks. In the meantime, the interim order dated 24/5/2023 shall continue. Yes.
So this work order was completed by the.
Yes. Who will say what? Yes. Who is the respondent?
PW.
Yes, PWD. Or Nayak, anybody. Bring them.
Have people lordship. In this matter, lordship, we have received the instruction from the commissioner, lordship. But government instruction is needed for us, lordship.
What is your instruction?
Instruction is received, lordship. Right, lordship. Lordship, kindly lordship, kindly para 4, let's see the para 4, lordship. The amount was not sanctioned by the completed authority, lordship. We have forwarded the government, lordship. But
No, without sanction, how can you order for an execution of work? Is it not a fraud? Is it permissible under FRBM? What is this? Who is the respondent here? You are representing whom?
lordship, I am respondent number 8, your lordship.
Respondent number?
8, your lordship.
Who will pay this money? Tell us.
Lordship, we are not. We, lordship.
What is the work? Government means you want an affidavit instruction from government. Which government?
Lord.
Government in PNRD.
Lord.
Isn't it? From the secretary.
Lord.
You are the representing.
Lordship, but the budget is not sanctioned from the government, lordship.
What do you mean by government?
Lordship, we are representing the commissioner.
Understand? The commissioner and secretary is the government.
But we
As
have,
per executive rule of business.
but lordship, we have
They are the executive head of the department. Or we cannot go to the cabinet. Or in a case for the minister, to the minister. Minister is not the government.
but the financial, lordship, the year financial year, lordship 2024-25.
Without any sanction, how can you order for an execution of work? And ask these people from pillar to post. Yes.
As per instruction received, my lord, a proposal was sent to the government, my lord.
What do you mean by government?
Government means, my lord, this was received from, my lord, the commissioner, my lord.
Have you taken permission from the government to execute the work without any sanction?
My lord.
Who asked you to?
These are the bills for the elections, my lord. The supplementary budget was proposal was sent, my.
When it was
NIT
sent?
was issued
When
by
it
the
was
deputy
sent?
commissioner, my lord.
When it was sent?
My lord. May I place the instruction, my lord?
Place us. That is, we are having it. Tell us.
Yes, yes, yes.
When it was sent? When work was executed?
That part, my lord, that was under deputy commissioner, my.
Understand?
Yes.
You do not dispute that here is a Panchayat election. Now
Yes.
next Panchayat election will be held, isn't it?
My lord. My lord.
Now who will pay this interest? The officer
The proposal
or the government?
My lord,
when the work was executed?
During the election.
When? Tell us the year.
2018, man.
2018.
Yes.
Now, when the proposal was sent?
Proposal was sent in the, I think, 2020, my lord.
Panchayat election held long back. Now it is 5 years almost.
5 years already. What? Yes, 2001. There are lots of, my lord. Yes, man. This particular repetition 2001, man.
Okay.
Instruction is for, my lord, overall budget, my lord. Not for particular this repetition, my lord.
Lordship, Honorable Court has already directed the respondent number 8 to page number 10. In which petition 929 to 2016 is both on 12/6/2016.
There are
Lordship, you
specific
details
specific
documentation.
direction.
Mm.
Earlier proceeding, there was a specific direction.
My lord.
Is not it?
Lordship, we have submitted detailed representation with all necessary. for-
You are for? Who are you? Tell us what is your instruction. According to you, did they execute the work?
It's part of what was executed.
Whatever is according to you, what was the due?
There was a bill of 59,000.
864.
Yes. And amount of plug was paid way back in public.
Now, according to you, 99,864.
Yes, of that one further bill.
Forget about, don't tell us all this. Tell us how will you pay, both of you or your officers will be here.
But my duty was to forward it to that.
We know everybody is performing their duties. When you require,
But it
you
ought
need
to have
to
been. Yes,
hold, you need to hold election without money.
But it is
Then you will call everybody, please supply, we will do this. Then everybody will supply, then people will run from pillar to post to get the bills. And even after there is generally in contractor bills, you ask to verify. Here is a case where there is a specific direction to sanction. No contempt file. Let the registry register a suo moto contempt. Against whom, tell us the names. Friday?
Run sometime, my lord.
Friday?
I'll take in.
Friday?
I'll take specific instruction.
Friday.
You have done at least your part. Let us, you give a copy of the instruction to him, let us have on Friday.
Yes, I'll have to put the take up.
Okay. Mr. Doctor.
Yes.
Learned Standing Council for the Learned Standing Council for the department submits that he may be granted time till Friday to obtain instruction in terms of this court order dated 15/2/2024, inasmuch as in the earlier writ proceeding, this court has issued a specific direction to sanction the payment to the petitioner within 6 weeks from 12/6/2019, and admittedly till date neither such amount has been sanctioned nor any payment has been. List on Friday.
If possible, my lord, on Monday, my lord.
Okay, on Monday.
26. Obliged.
Give return back. Mr. Dutta, take
My lord. Obliged.
30.
May I please, your lord?
Yes, now who is in this? Who are respondents here?
I am there.
Mr. Dhar seems that all development work are being done by the contractors without any sanction, and they are running from pillar to post until and unless you say that no, they have not executed.
No, my lord, what happens actually in this work, my lord, initially we have sanctioned. When it lapses, my lord, we have to go for revalidate.
Whatsoever you do that, if they have executed, see, they are also businessmen. They will take loan, they will execute, will not award any interest here.
My lord, here I understand.
Tell us, when will you file an affidavit or instruction?
90% we have paid.
Okay.
10%, only 2 lakhs, something is remaining. We have paid him.
You are mighty government. His 10% is nothing for you.
My lord.
When, tell us. If 90% is paid, we will wait for some time.
Well, 2 weeks, I will get the instruction.
Okay, Mr.
My lord, for a moment, may I submit one thing? Affidavit filed by the ICR may kindly be taken for a moment.
Who filed affidavit?
Indian Council of
This matter relates to whom? Union of India.
Union of
There is no
no,
affidavit
my
here.
lord, not Union of India. Indian
ICR.
Council of
ICR, PWD
There is no affidavit here.
affidavit filed by
Drain, dung, pit, waste, ICR, NCR, Rani. Isn't it?
yes, my lord. It is filed on 8/12/2023, my lord.
No, they have prepared, might have prepared, they have not filed it. Sir, file it. You are for ICR.
No, I am for PWD.
This is the copy, my lord.
Who is for ICR?
I go for my lord. His name is
Name is shown.
My lord, what happened in this case? Actually, the work order was issued by the ICR pro PWD.
Hmm.
Thereafter, while the bill was placed,
Hmm.
the PWD is
Now, what kind of order are you expecting here? Today.
my lord, as per the letter by the ICR, the entire payment, excess payment has been made to the PWD regarding this work order.
Now, what is the order you want to pass today?
Within a limited period, the amount may be paid.
Then file a contempt after a month.
Yes, my lord.
So we'll ensure that money is paid. Or you want an disposal order consideration, verification, and want to file a contempt.
This is an admitted amount, so I do not think that it is
This is an admitted by ICR. They have not said who will pay.
No, my lord. This is not ICR. This is by the executive engineer, my lord. Page 17.
17 of what?
Of my writ petition.
Affidavit is not before lordship.
No.
My writ petition, man.
No. So you want to say that without affidavit, we'll have to say that this document is genuine.
They have not said that this is, they have not challenged, they have not contradicted this
That's
document.
why he said that I want to obtain instruction, file an affidavit.
And
So therefore, I have asked you, what kind of order do you expect? If you want an order to direct them to pay, then this court will have to have a satisfaction that this was a genuine work order, this was not been disputed, this is admitted, isn't it?
Yes.
Is it not that law? Otherwise, we'll have to send you to the civil court.
And
that's why I've asked you what kind of order you are expecting. You will have to say within a judicial parameter that lordship can pass this order with this material.
I was submitting on the basis of the affidavit, but it's not in the record.
No, forget about not in the record. I can look into the affidavit, not a problem. So do you say that on the basis of that, I can issue a direction to the PWD to pay the bill? Do you propose that?
My lord, this document is issued by the executive engineer. If you go back thoroughly,
we are trying to learn our power of judicial review. That's why too much of times are being taken in a court proceeding. Yes, Mr. Thor, if affidavit is there that we have paid, our work was executed by PWD, we have paid the money, then why have you not paid? Give a copy of the affidavit to Mr.
Whether this is filed, my lord, that is the thing.
No, ICR has filed. Might be. It is submitted that an affidavit has been filed by respondent number 5 on 3 on
8/12/2023.
8/12/2023. Same is not on record. Registry to verify, and if such affidavit is filed, take the same along with the record. Also, in the meantime, it is submitted by the learned counsel for the petitioner that in the affidavit, the respondent ICAR has taken a stand that the work was executed through the PWD and the entire amount has already been paid to the PWD. In that view of the matter, Mr. Thor shall obtain instruction whether they have received the amount against the work order in question from ICAR, and if the PWD has received the aforesaid amount, why such payment is not made to the petitioner. This order at best we can pass.
My lord, date may be.
Huh?
May I pray for
Affidavit is filed, na?
Yes,
Affidavit is filed, but it's not on record. Huh? Affidavit filed on 13/12. Writing down 13/12/2020.
Next date may kindly be.
Give a date. It's difficult for this court to give a date because we are sitting for 3 days now. We do not know how this other bench is fixing the matter. Make a mention.
Right.
Huh?
Public.
Make a mention. Moment affidavit is filed, make a mention. Yes, what is this?
My lord, for detention of the vehicle without issuing any seizure.
Ah,
So he is to obtain instruction.
yes.
Yes, my lord.
What yes?
My lord, we have detailed instruction, my lord.
Give us. What is your instruction?
It was not seized by any authority.
Then where is the vehicle?
Vehicle is lying near where the seized of Burmese vehicle were parked. They abandoned themselves and they never approached any authority, my lord. And to annex, they have annexed representation.
File an affidavit.
Yes, definitely.
You file an affidavit, you go and have your
And
vehicle.
And in the meantime, my lord, your lordship may release the vehicle, my lord.
Why should it, if they are saying we have not seized, from whom will we pass a direction?
My lord,
Their stand is that we have not seized it. How can you pass a direction? File an affidavit and close this repetition.
If they do not seize the vehicle, how the better not is nowhere in from the vehicle.
File a reply to this affidavit.
Moreover, my lord, the police authority are coming to know this fact. Send a notice you take your vehicle after producing proper documents.
Then how are you to send them a notice to
No,
keep
no,
proper vehicle?
no, my lord. They first time came to know after receiving the notice from the honorable court.
Then did you seize thereafter the
No,
vehicle?
no.
Then why are you asking them
For
to
the inquiry? Because
file an
Okay,
affidavit?
okay,
Don't take double standards.
No.
We know how to handle this police.
my lord, I will file.
If you are saying at the one day we have not requisition.
No, it is subsequently.
So did you subsequently seize the vehicle?
Not it.
Then how under what authority you are asking them to take the vehicle, produce document if it is not within your custody?
Not our custody, my lord.
If something is not within my custody, under what authority I will ask them to produce the record, produce the document?
What may I come?
Yes.
After receiving notice from the honorable court, SP directed the additional SP to cause an inquiry. Accordingly, additional SP found the vehicle
Lying
near
on the
one
road.
Yes. Thereafter, additional deputy commissioner submit report to the SP. Then SP asked the OC to bring the owner. Then they came, but there was also a report from DTO, from local DTO, where it was found that the vehicle is from Nagaland and the owner is also from Nagaland.
Okay, fine.
The chassis number is manipulated.
Okay, fine.
Then there's
Now, have you registered any case?
No.
So if you are not registered any case, under what authority you are doing?
They can take vehicle. They can take their vehicle because we have not seized.
Okay,
This is our state.
Fine. If you are not seized, they will come and take this vehicle. And if you are keeping your eyes closed, even if you know that these are a manipulation.
Unless an observation is made, my lord, how can I take the vehicle?
Why should we make an observation?
Because the vehicle is stranded on the road from 20.
They are saying that we have not seized. Go and take the vehicle. Who has said that not to take? Why should we come into all this? Let them file an affidavit. The learned counsel for the respondent submits that he has received an instruction that they have not seized the police authority has not seized the vehicle in question. However, he would like to file an affidavit in this regard. Accordingly, praise for 2 weeks time. Prayer is allowed. List after.
My lord, 83,000 per month loan amount is there, my lord.
But how can I do?
My lord, a short date, if it is short date, even 7 months.
This is not our vehicle. We have not seized it. Go and take it.
Who will pay the compensation, my lord? If I
File a civil suit. They are saying that they have not seized it. Who have asked you not to take your vehicle?
Then from the vehicle, how the metal nut was taken away, my lord?
We do not know. So you lodge an effort that somebody has taken away your betel nut. These are my Betel nut I have purchased, taken away.
My lord, at least what date may be given.
No death, no death. You left the place. Moment you are, and they are also waiting. Let him come. You know.
The situation is different.
Okay, we'll know from the situation from his affidavit and you reply. Yes, next case. Yes.
Non-payment of my lord, expired charge, my lord. And already, my lord, the bill was forwarded to the.
Okay, learned counsel for the respondent submits that he has received instruction and will file an affidavit within a period of 2 weeks from today. List of the 2 weeks. You file an affidavit, what is the right? They are entitled.
Admitted amount.
So you file an affidavit, we can pass a direct.